get going?
Yes, thank you very much, Chair. We're good to go.
Great. I declare open this hearing of the Senate Economics Legislation Committee into the Future Made in Australia Production Tax Credits and Other Measures Bill. I begin by acknowledging the traditional custodians of the land on which we meet and pay my respects to their elders past and present. I extend that respect to Aboriginal and Torres Strait Islander peoples here today. The committee will be conducting today's hearing via video conference, teleconference and in person. These are public proceedings being video streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer, having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. I remind committee members and witnesses who are appearing via video conference and who are not speaking to please mute your microphones. And I now welcome representatives from the Clean Energy Council and the Superpower Institute. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, would you please state your full names and the capacity in which you appear today? I'll start with the Clean Energy Council.
Yes, thank you, Chair. Anna Freeman, General Manager for Advocacy and Investment at the Clean Energy Council.
Welcome, Ms Freeman, and the Superpower Institute.
Thank you, Chair. Bathan Mullen, I'm the CEO of the Superpower Institute.
Welcome, Mr Mullen. Ms Freeman, do you have a brief opening statement that you'd like to give?
Yes, I do. Thank you very much. Well, thank you, Chair, for the opportunity to appear today. It's quite an exciting bill that we have you have before you, and we're really pleased to be able to speak to it. The Clean Energy Council is the peak body for the renewable energy sector in Australia, representing around 1,000 businesses operating in Australia across solar, wind and hydropower, energy storage and renewable hydrogen. Our mission is to accelerate Australia's clean energy transition, and so we are strongly in support of the Production Tax Credits Bill, which provides the broad-based support that we've been calling for the past couple of years for attracting investment in renewable hydrogen production in Australia. The production of low emissions hydrogen in Australia will not only support a number of Australia's existing industries to meet their decarb targets and commitments over the coming decades, but it will be important for unlocking new economic growth opportunities. The body of work that's been undertaken over recent years, including by the likes of the Superpower Institute, demonstrates that these economic growth opportunities could be vast. We just saw a report released in December by the Chamber of Minerals and Energy in WA, commissioned from Mandala, that said that were WA, which is the largest exporting region for iron ore, to supply something like 14% of global green iron production by 2050, it could generate $74 billion in additional economic value and support almost 20,000 ongoing direct jobs. So the size of the opportunity is large for these industries that hydrogen would support. But it's also important for other types of industries as well, not just green metals, including low carbon liquid fuels such as e-kerosene, clean ammonia, methanol, which will be particularly important for hard to electrify heavy transport such as aviation and shipping. That would reduce our dependence on fuel imports and vulnerability to supply shocks and create new clean energy processing and manufacturing opportunities in Australia. The key message for the committee is that without this hydrogen production tax incentive through the bill, and without internationally competitive hydrogen, these growth opportunities won't be realised in Australia. And that's because, as we've we've heard over the many years now, it's more economically efficient to locate value-added processing and manufacturing activities close to the point of production. So this policy is important as a catalyst for the growth of new Australian industries. And without it or other commensurate policy and support measures for clean hydrogen in the near term, we are unlikely to convert that strategic advantage into real economic benefits for Australia over the decades ahead. And that would be a highly regrettable missed opportunity for Australia. The production tax credit scheme itself is a relatively simple, transparent and efficient mechanism. It's broad-based and it invests public funds sensibly by crediting verified and eligible production. It's not received by firms that do not deliver. It will not fully address the production cost gap. It's going to take some time for the prices to come down, the costs to come down. So project owners are going to be incentivised to continue to work to drive down project costs over time and to also access complementary sources of funding or support. While there are probably a few tweaks to the bill which could further increase its impact, overall we regard it as a no regrets measure and we urge the Senate to support its swift passage. Thank you, Chair. And Chair, sorry, you're on mute.
First hearing of 2025. Thank you for that. And Mr. Mullen, did you have a brief opening statement that you'd like to give?
No opening statement, Chair. Happy for our submission to stand as an introduction to our thinking on these issues. Thanks.
Great. Thank you very much. And I just welcome my colleague, Senator Smith, who's joining us, and I'll come to Senator Smith in a moment for any questions. I'll just start with you, Ms. Freeman, with some questions. The bill in this inquiry from the submissions has been very well supported, and we know that many people here today have asked for, in their submissions, the bill to be passed as a priority. And you've said in your opening statement there and also in your submission, we urge the Senate to support its swift passage in this term of Parliament. Why do you see that it's important to pass the bill and put these measures in place quickly? Now you're on mute and I can return the favour.
Damn it. Sorry. Thank you. The reason for that is because at the moment projects are facing higher costs than they can recoup through potential offtake contracts. And unless we can very quickly get the costs down for projects in Australia, our fear is that the investment will go to other places that have more attractive incentives. So Canada, for example, has already got support in place and probably is one of our big rivals when it comes to attracting investment in clean hydrogen production for the same purposes of supporting industrial decarbonisation, but also future emerging markets. So I think our main concern is once we see other jurisdictions both build and then maintain and retain that competitive advantage over Australia, it'll be difficult for us to, I guess, in a few years' time, attract investment. But once it's taken a foothold in other markets, it's going to be more difficult for Australia to attract attention. So it matters that we aren't slow out of the blocks. At the moment, we probably are already slower out of the blocks than we need to be. So we really can't afford to lose more time, and our fear is that if it takes another few years to offer something like this, it doesn't have to be this scheme. It could be a carbon price, but in the absence of something that is going to incentivise investment in lower emissions commodities, well, we're going to struggle to attract that investment.
Okay, thanks for that. So it's a really critical time in the development of these industries, critical minerals and low emissions renewable hydrogen sectors. When you look at the world economy and other countries developing those technologies backed by support from their governments. The Future Made in Australia agenda, Ms. Freeman, that this bill is part of is about supporting industries that are critical to a net zero economy, and also supporting industries that are critical to our security as well, as we make that transformation. And the production credits are designed really to address the initial cost barriers in developing these sectors and getting them off the ground. Why is it important for the production credits to act as an incentive and an accelerator in the early stages of commercialising and developing economic opportunity in these sectors?
First of all, because, well, it is a higher cost commodity that we are producing. And then obviously in an early stage to producing clean hydrogen in Australia, it's more expensive than emissions intensive hydrogen. And so there needs to be some account taken for that. And then there's the learning by doing. We're doing all of this for the first time, and we're seeing very large capital investments at stake, and we need to do what we can to reduce the level of commercial risk for the early movers when they are, first of all, needing to find offtake markets, which can be less certain. Their margins are likely to be tight, and then there's, I guess, higher financing and investor risk associated with these projects, and that bears a cost to those projects because it's not like they can immediately point to the project that was just done 3 months ago or last year and say we've got all of the team that can be moved on to this project to deliver this. Or we've done this before, we've proven it works. There's a higher risk and that attracts a higher financing cost. So there's a whole range of reasons. Plus, we're still suffering from the effects of COVID and the Russian invasion of Ukraine in terms of higher inflation. It's settling, it's coming down, but it's going to take a while for that to completely be a thing of yesterday, and in the meantime, projects are witnessing higher project costs, including for renewables. So, for example, renewable energy generation projects saw their project costs go up by 30 to 40% during COVID. And that makes it much more difficult to get those projects off the ground. And obviously, they're a really key component of a hydrogen project.
Yeah, thank you. You described in your opening statement and also in your submission the measure as simple and efficient. How would you kind of characterise the measure itself, the two sets of production tax credits, and why is it important to companies for them to be structured in a pretty simple and efficient way?
What we like about this is it's not an application process. It's in legislation. It's clear what you need to do to be eligible. And so then investors can look at it and say, am I eligible? Do I meet the criteria? And if I meet the criteria, then I get it. And that provides a great deal of, confidence to both the project proponents and also the financiers and investors that they know in legislation there is something that says if you do this, you get that. And that is the sort of broad-based policy that we need in Australia to drive long-term investments.
Great, thank you. Mr. Mullen, the Superpower Institute talks in its submission in support of these measures, in part in the absence of there being a carbon price, which could also disincentivise carbon-intensive sectors and incentivise low-carbon sectors. And you talk about the initiative as an important step to unlocking Australia's exceptional green export opportunities and supporting prosperity here in Australia as well as global decarbonisation efforts. What challenges would you see for producers and processors here in Australia if there wasn't support like these production tax credits, especially from your perspective in your institute, given the absence of a carbon price?
Sure, thank you, Chair. Our view is that this is essentially an environmental challenge and an economic challenge that is best viewed through an economic lens and applying, really conventional economic tools. The current situation in Australia and around the world largely is that fossil fuel production of industrial processes like hydrogen imposes costs on society that those polluters don't have to pay for. And the most efficient tool to deal with that kind of a situation, to deal with the economic externality, is to impose a price on carbon. And largely around the world, we don't have those mechanisms in place, with some exceptions. The first best option for Australia is to introduce a carbon price to deal with those kinds of problems. But in the absence of that, a tax credit for hydrogen, green hydrogen, is a useful surrogate. So the challenges for production at the moment are essentially that green producers aren't playing on a level playing field. They're up against producers of hydrogen that use fossil fuels, and those producers that use fossil fuels don't pay for the costs that they impose on society. And while that playing field isn't a level one, green producers will be at a significant disadvantage and will effectively be impossible for them to compete with those fossil fuel producers.
Thank you. And then I guess just finally from me, on the flip side of that, what do you see as the opportunity for critical minerals processing in Australia, for renewable hydrogen in Australia, if we can put these measures in place, and why is it important to grow those industries?
Yeah, sure. Our focus is more on the renewable hydrogen side of the equation, more so than the critical minerals, but the opportunities for Australia are immense. This green export opportunity has the potential to underpin economic prosperity for many decades to come in Australia, and that's in a context of a world that is seeking to decarbonise and will rely less on fossil fuels. And Australia's large export industries that are fossil fuel based can be expected to shrink over time. And we need to replace those industries with new ones that are zero carbon and that generate a lot of economic activity, a lot of investment, a lot of jobs that help to raise real wages. And the opportunity that green hydrogen presents underpins a lot of these industries. So, for example, green iron is a good one. So our estimates are that green iron could be an export industry of up to $400 billion for Australia, and over the long term, and that's an industry that could be, similar size to the fossil fuel industries we have today, and that's what we really need to be aiming for.
Fantastic. Thank you very much. I'll share the call now and go to you, Senator Smith.
Thank you very much, Chair. I just want to turn to the matter of the community benefits principles. Can you both share with the committee whether or not you consider yourself to have a mature, detailed understanding of how the community benefit principles will work, or whether or not you have whether your understanding is very broad and shallow? And then I'm keen to understand how you expect, or how you know that how the community benefit principles will be implemented and enforced.
Shall I commence? Thank you, Senator. So I would say that we have a broad understanding of how the community benefit principles, what they are in general, and we support the intent of those principles. My understanding is that there will need to be work done in the rules in terms of how this is actually going to be applied, and that's important that there is industry engagement on that. One of the issues that we raised within our submission is that investors will need some clarity about how those community benefit principles will be applied and what the expectations will be at the outset of the project. So what's involved in meeting them, in the same way that I talked before about the importance of investors being able to see how to qualify. It extends to the community benefit principles as well. So what will the things be that they will need to do to meet the requirements or those principles that are spelled out? And at the moment, they're at a relatively high level. We'll need some tangible and objective, forms of being able to demonstrate compliance with those principles, because if there is uncertainty about whether or not certain actions that may have been taken or steps that have been put in place by proponents to meet those requirements, if there's any grey area in those, in how they meet those obligations, then that can lead to some investor uncertainty in terms of whether or not they will satisfy those requirements. So it will be important to work with industry in order to get that right, but in general and overall, we support the intent of those principles.
Turning to me, Senator.
Yes,
Thank
Mr.
you.
Mullen, yep.
The community benefit principles have not been a major focus of our work on this bill. However, I can say at a high level, we support the concept of community benefit principles as a way of ensuring that the benefits of economic activity generated by this kind of mechanism are shared broadly, and that the communities that most affected by both the closure of fossil fuel-based industries and the development of new industries in their place, that those communities benefit appropriately from such mechanisms.
Have you been given a time frame in terms of when that clarity that you mentioned, Ms. Freeman, when that clarity will be achieved? And secondly, do you expect that non-compliance with the community benefits principles will incur financial penalties?
So I don't have a time frame. My understanding is that there will be consultations, so I'd be awaiting that consultation process, and we'll be actively engaging in that. I don't expect any investors and project proponents will not want to comply. It'll be in their interests to do so, both because that will likely strengthen the community support for these projects, and also it'll be important for attracting the incentives. As to whether there's a penalty, I don't know. There's no clarity really at the moment, as far as I understand, Senator, in case I may have missed something in terms of how that would work. But presumably that will come forth as part of the consultation.
Mr. Mullen, do you have a comment?
No, nothing to add to Ms. Freeman's comments. Thanks, Senator.
Thank you very much. The AMWU has told this committee, when it was considering the Future Made in Australia Act, that these requirements, the community benefits principles, would require a requirement for a union agreement. Is that your understanding of the community benefit principles, and would you agree with that?
I don't know. I haven't heard that. My understanding, and I'm going off memory here, Senator, is that there's a requirement for well-paid and secure jobs. We'd like to see that principle, but it is now in legislation, probably worded more along the lines of fair paying conditions. In terms of requirements for union membership, I have not heard that. That's something we'd be interested in engaging with.
I said union agreement. Union agreement.
Right. Apologies. Yeah.
Mr. Mullen, do you have a comment?
I'm not familiar with the AMWU's position on this, Senator.
Ms. Freeman, in your opening remarks, you did make the point that it would take some time for project costs to fall. What other policy initiatives would assist in reducing project costs for potential projects under this initiative?
Well, there's a range of different things that need to happen. First of all, I talked earlier about inflation, and we're really looking forward to inflation costs falling, which will have direct positive benefits for renewable energy project development. And electricity itself is around 70% of the total operating expense of hydrogen production. And so the real key here is that we need to get electricity costs down, and that will be a key part of making projects highly successful. And that's really what we're going for here, is that we expect over time Australia should be a low-cost producer of clean electricity, and that will result in long-term sustained low electricity costs for energy-intensive users, of which hydrogen would be one. So that will be one thing. There's a range of other things that are going to help. There's obviously a capacity investment scheme in Australia at the moment, which is developed to reduce revenue risk for projects, and that should help additional projects to come forward at an accelerated rate over the next few years. So that's helpful. Other things like rewiring the nation and investment in infrastructure, supporting enabling infrastructure for clean energy projects will also be important. I expect there'll also be support coming from offtake markets. So, for example, there are some incentives for and contract for difference schemes internationally that Australia has prospects of attracting, and that will help to close the gap further in terms of what projects need to do to be viable.
Mr. Mullen?
Senator,
and just final question there, Senator Smith. Thanks.
Senator,
excuse me, Mr. Mullen. Chair, I don't know if that time was given equally between yourself and myself. I've not been keeping time, but I've only got a few more questions.
That will reduce your time with the Minerals Council, but that's up to you. So, Mr. Mullen.
Senator, I'll briefly refer to three other mechanisms we think are important in reducing project costs in relation to green hydrogen. The first two of which are mentioned in our submission, and they relate to two other market failures that are relevant to green hydrogen production. The first is innovation spillovers. Ms. Freeman referred to this kind of thing earlier. This is the fact that early investments in green hydrogen will produce knowledge and learning that will be of benefit to others. And so those spillovers should be recognised and appropriately incentivised by government. The second one is common user infrastructure, things like electricity transmission, hydrogen pipelines, storage, things of that nature have common user features, and it's unlikely that any one project proponent can efficiently invest in that kind of infrastructure. So there's a role for government in providing funding for certain types of infrastructure in that space. And the third one I don't believe was mentioned in our submission, but the approvals process and the speed of projects being approved in Australia is far too slow, and we would like to see significant action on making those processes more streamlined so that we can get things built more quickly and that these projects can get off the ground faster.
Thank you very much. Paragraph 1.51 of the explanatory memorandum states that the amount of the offset that a company is entitled to is reduced if the company does not comply with the community benefit rules. Is that your understanding, Ms. Freeman?
It's been a while since I've read it, Senator, so I didn't recall that, but that's good information for me to have. Thank you.
Great. Thank you very much.
Thank you.
Thank you both for your participation.
Thank you.
Thank you.
Thank you. Thank you. I'll do that part. Thanks, Senator Smith. So thank you to both of the witnesses for appearing today. Committee's agreed that responses to questions on notice should be provided by 28th of January 2025, and we now invite you to disconnect from the video conference. Thanks.
Thank you.
I now welcome representatives from the Minerals Council of Australia and the Australian Chamber of Commerce and Industry. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, would you please state your full names and the capacity in which you appear today? And we'll start with the Minerals Council.
Thank you, Chair. Ross Lyons, General Manager, Taxation, Minerals Council of Australia.
Thank you, Chair. Matt Dunia, Principal Advisor, Indigenous Partnerships and Communities, Minerals Council of Australia.
And you're on mute, the current Minerals Council witness.
Chair, Ross Lambie, Chief Economist at the Minerals Council of Australia.
Welcome. And is that all of you from the Minerals Council today?
Yes, it is. Our other member was on a plane, and I think the plane got delayed.
No problems. Thank you very much. And Mr. Grist, if you'd like to introduce yourself for the Hansard record.
Yes, Peter Grist, Director of Economics, Industry and Sustainability at the Australian Chamber of Commerce and Industry.
Thank you very much. Thanks all for being here. Does the Minerals Council have a brief opening statement?
Yes, we do, Chair. Thank you very much for the opportunity for us to appear today in front of your committee. We welcome that opportunity. I want to firstly talk in relation to the Critical Minerals Production Tax Incentive. The MCA supports the Critical Minerals Production Tax Incentive because it is a positive step toward attracting investment in the critical minerals industry. However, the development of a downstream critical minerals processing industry will require more than this policy in isolation. There is inherent risk in viewing this policy as a silver bullet. The reality is that despite its best intentions, this incentive is in conflict with a range of government policies that actually restrict investment, limit job growth, and make Australia less internationally competitive for new investment. If the government's serious about unlocking Australia's vast critical mineral deposits and building a sustainable and vibrant downstream processing industry, we need to get the fundamentals right first. Investors are reluctant to commit to new projects in an environment of increased government regulation, risks of adverse taxation, in particular changes to long-standing policies such as the fuel tax credit. Investors are also balking because of the federal government's rewriting of industrial relations law that compound the cost of labour, tie companies in red tape and litigation, and further weaken productivity. In addition, investors are concerned about the rising tide of environmental restrictions and lawfare and access to reliable, stable and affordable energy. These are the fundamentals that need to be addressed to attract investment. Given the risk profile of projects, miners and investors always look at the full picture of government policies and regulations before approving a final investment decision. One good policy that aims to address a production cost disadvantage won't be enough to offset these other risks. We also remain concerned about the potential duplication of process created by the community benefit principles. We support community benefit principles, but the processes may create further barriers and uncertainty as to project eligibility. These concerns are not ours in isolation. They've been raised by the West Australian Government and other industry groups. We encourage the government to consult with industry in relation to this important aspect of the bill. I also want to comment briefly on the amendments relating to the Indigenous Business Australia. Australian mining has a proud, long-standing record of collaborating with traditional custodian communities. In the 2022 calendar year, MCA member companies reported approximately 949 million in goods and services procured directly from 488 Indigenous businesses. Aboriginal and Torres Strait Island peoples were approximately 6% of the workforce, which included approximately 10% of all mining apprentices and trainees. To maintain the minerals industry competitive edge and increase wealth generating opportunities for Aboriginal and Torres Strait Islanders, Australian government and the mining industry must continue to work together to develop appropriate enabling policy frameworks that maintain Australian mining industry competitiveness. The MCA has long encouraged localised approaches and collaboration efforts between project proponents and host communities. Host communities are critical to the success of Australian mining, and the industry fosters relationships at a local level to ensure the benefits flow through to host communities. The community benefit principles, which I referred to earlier, cannot be used as an excuse for policy overreach, with the MCA encouraging the government to remove the proposed existing and separate legislative frameworks of industrial relations and taxation from the community benefits principles. Collaborating with mining communities to develop stronger and sustainable supply chains will foster greater opportunity for highly skilled and inclusive workforces that promote mining careers for youth, women and traditional custodians. Thank you very much, Chair.
Thank you very much, Mr. Lyons. And Mr. Grist, did you have a brief opening statement?
Yes, I do. Thank you, Chair. Thanks for the opportunity to appear today. ACCI believes that further investment in key industries will be necessary for the transition for the Australian economy to a low emissions future. And we consider the introduction of production tax incentives has the potential to unlock investment in the development of domestic renewable hydrogen and critical minerals industries. At the same time, we note our concerns that tying access to the production tax incentives with annual compliance of the community benefits principles represents a considerable risk that will increase the cost of doing business. Australia is a high input cost country. Construction costs, regulating environmental approval processes, as well as labour costs and the onerous industrial relations system weigh heavily on the cost of production in Australia. As such, Australian businesses face significant challenges when considering large-scale investments, particularly when adopting new low-emissions technology. Production tax incentives offset part of the difference between the higher production costs of new technology relative to established processes, giving the investor a level of certainty that a reasonable price for their goods and a return on the investment in the initial years of production. While ACCI supports the use of production tax incentives to assist emerging industries, over the long term, renewable hydrogen and critical mineral industries must be profitable and sustainable without continued government financial support. ACCI agrees that it is sensible to access to the hydrogen and critical minerals production tax incentives is time limited to 10 years. That said, we are concerned that the window to access the production tax incentives is very narrow, with the final investment decision required before the 1st of July 2030. There are many regulatory requirements in gaining approval, particularly the regulatory approval, which consistently experience considerable delays. ACCI recommends that the date for the final investment decision should be extended to the 1st of July 2035. For hydrogen production tax incentives, ACCI urges consideration be given to processes involving carbon capture and storage, blue hydrogen, if it can be achieved at the threshold emissions intensity of less than 0.6 kilograms of carbon dioxide per kilogram of hydrogen. For critical minerals, ACCI suggests a production tax incentive of 25% of expenditure directly related to processing into more concentrated elements is more appropriate, given the more stringent regulatory hurdles and high labour costs that businesses face in Australia. ACCI has major concerns about the government's intention to tie access to the production tax credits with adherence to the community benefits principles. This will drive up costs, complexity and compliance, and be a major retardant on investment that the scheme is designed to achieve. The focus of the community benefits principles on secure jobs, diverse workplaces, and engaging with local communities appears to relate more to achieving other government agendas unrelated to investment in renewable hydrogen and critical minerals. They also duplicate other regulatory and business and processes that businesses must already comply with, such as the new Secure Jobs Better Pay legislation and the community consultation requirements for planning and environmental approval processes. They'll be expensive and complex to administer, and the annual compliance requirements will add considerable uncertainty to the financial viability of what are very long-term investments in processing capacity. For businesses investing hundreds of millions of dollars in multi-decade hydrogen and critical minerals-based projects based on access to the production tax credits in the first 10 years, compliance with the community benefits principles adds considerable risks that will undermine the viability of the whole investment. Yep, I can finish there.
Yeah, thank you very much, Mr. Grist, because I know Senator Smith will want his 10 minutes with you there. So thank you very much. I'll just start with the Minerals Council, and I have your submission, and I listened to your opening statement there, Mr. Lyons, and I just want to clarify your position in relation to the passage of the legislation. So I think in your opening statement you said words to the effect, and you can correct me, that you support the production tax credits, you support the bill, but that you think the agenda that you've already laid out for us today and laid out for us in your submission is more important to pursue in order to grow a critical minerals processing industry in Australia. Can you clarify your position for us on the bill?
So on the bill, look, we support the bill because the bill is going to help to reduce the cost of production for people that develop facilities downstream. Our concern is that in the absence of making the changes to the fundamental policies that we outlined, you're not going to see the investment in the downstream activity in any event. So it's an overall package. The entire, I suppose, holistic environment needs to be addressed, and to make Australia more internationally competitive in order to attract the investment, because we are competing for investment, as we well know, and it's probably got even more competitive this week as a result of the incoming president in the United States.
Yeah, okay, thank you very much for clarifying that. The Minerals Council, of course, has a number of member companies who could benefit from the production tax credits, like rare earth companies, lithium companies, mineral sands companies. Can you just outline for us what the benefit of the production tax credits could be to some of those companies who are your members?
Certainly. Well, I mean, as we know, it's limited to the 31 critical minerals on the list, so it doesn't include other sort of critical minerals that we think should be on the list, including, copper, for instance. But we've got member companies that have existing downstream facilities. They've already invested, so they will benefit from the critical minerals production tax incentive when it commences on 1 July 2027. In terms of, we've got a lot of other members that are mining the mineral obviously that's not eligible for a critical mineral production tax incentive, and they're in consideration of whether they go to downstream processing as well. This will assist with the decision making. The important part here, of course, is that companies need to be able to be certain of their eligibility for the critical minerals production incentive, tax incentive, before they make their investment decision. So certainty is very, very important in that process. And there are aspects of the bill, obviously, that are creating uncertainty in terms of that, which we've addressed in our submission.
Thank you. Our first witnesses, so Ms Freeman from the Clean Energy Council, talked about the way in which this is a relatively simple measure because it's not an application process and the eligibility is set out clearly in the bill. Do you see the measure, Mr Lyons, and in your role as General Manager of Taxation, as a relatively simple and efficient measure?
Not really.
Compared with a grants kind of process? Not
really. I think the issue that's going to be there for companies and taxpayers is the role of the tax office. We've seen, like at a similar measure, the research and development tax credit, massive disputes with the tax office in terms of determining eligibility. And here, the tax office have got a critical role to play in terms of deciding the nexus between the expenditure and the project. And the nexus rules are going to be look to be quite confusing as to determining what does have a close nexus. For example, transport costs, which I know I've read in submissions, a number of people that have written submissions in have said transport costs should be an eligible expenditure item in terms of the critical minerals production tax incentive. I mean, I've spoken to Treasury about that, and their view is a vague answer, but a vague answer which says, well, the cost of transporting within the facility would be eligible, but the cost of transporting from the mine to the facility would not be eligible. I mean, you're going to have those sort of issues associated with this sort of tax incentive. So I don't think it's going to be that simple, actually. It'll probably be quite complex.
Okay. I wanted to ask you a couple more questions, but Senator Smith is keeping me to time. And so I'll just ask Mr Grist a question. You don't like the community benefits principles. And I'm wondering whether there's a particular community benefit principle that you don't like. The community benefits principles, include things like tax transparency and secure well-paid jobs. Are you opposed to those community benefits?
Well, there are elements of the community benefits principles which we think duplicate existing processes. So we think that they are unnecessary. We are concerned that the requirements such as promoting safe and secure jobs can be interpreted as requiring union negotiated enterprise bargaining agreements, and I think it was referred to with the previous panellists that there is a possibility that it would require union membership on sites. So we are very concerned about that. Similarly, the requirement for community engagement, we think that, and specifically First Nations engagement, that's a requirement of planning and approvals processes, and so we are concerned that it's duplicating that, and particularly the requirement that the businesses need to seek approval on an annual basis from either the Clean Energy Regulator or the Department of Industry, and requiring them to prove that they're consistent with the community benefits principles every year. We're concerned that that represents a considerable risk to business.
Do you think that community expectations that there be community benefits if companies are receiving public support via the taxpayer are wrong? I mean, do you disagree with the concept of, you know, when companies get public support, there should be a community benefit and they should be accountable and transparent about that benefit?
I don't disagree that there shouldn't be community benefits associated with public investment, but I think that the community benefits principles extend too far, and the requirements, particularly if they're going to need to prove annually that they're meeting the community benefits principles, are just too onerous.
Will ACCI participate in the consultation on the community benefits?
Oh, yes, we definitely would. Yeah.
Thank you. Senator Smith.
Thank you very much, Chair. Mr. Grist, can you explain how it is that the community benefit principles increased costs for projects?
Well, as I mentioned, they're duplicating existing processes, and so particularly like having to have regular and consistent community consultations when you've already gone through the process in getting planning and environmental approval for a project, and also the requirements under requiring secure, well-paid jobs. We're concerned there that, as I mentioned, that it'll lead to an implied requirement of union membership on all facilities, which will lead to increased. Potentially lead to increased industrial action and lead to higher cost of businesses.
Thank you, Mr. Grist. Mr. Lyons, in your remarks, do you expect that the complexities and uncertainties that exist in the research and development incentives to be replicated in this initiative in regards to engagement between proponents and the Australian Tax Office?
Unfortunately, I do, Senator, because of this concern about having to identify costs that have a nexus with the project, particularly for people that have got a mine and then a facility, and the costs generally within the company. There'll be crossovers of people that are working on both. There'll be crossovers of costs that relate to both, and there'll be need to be allocation and apportionments. And so I suspect that there'll be disputes between taxpayers and the ATO in relation to trying to, solve those issues.
Is it right to expect that project input costs like environmental approvals, industrial relations reforms, etc., if they are expected to be on an upward trajectory over the medium to long term, doesn't that upward trajectory undermine this particular approach?
Well, Senator, that's probably the nub of the point we were making, which is that the CMPTI by itself is not the silver bullet. There's all these other policy measures that need to be addressed to make Australia more attractive for investment.
Is there any evidence that those other matters are being addressed, or that they're on a positive trajectory?
Well, we're of the view that they're on a downward trajectory at the moment.
I just want to turn you might have heard this in a previous question I asked witness. I just want to turn to some evidence that the AMWU gave this committee when it was considering the Future Made in Australia Act. And in its evidence, it was quite clear that there should be requirements for union agreements. Is that your understanding of how the community benefit principles will work?
No, and that's quite concerning. I wasn't aware of that. I don't know whether my colleague Matt Denyer has any comment on that, but that would be of a concern. Would certainly add a lot of complexity.
Thanks, Mr. Lyons. Thanks, Senator. No, we weren't aware of that at all, and it is quite concerning to hear that, Senator.
Paragraph 1.51 of the explanatory memorandum states that the amount of the offset that a company is entitled to is reduced if the company does not, or the project does not comply with the community benefit rules. Were you aware of that, and is that your understanding? Both to Aki and to the MCA?
Thanks for the questions. That's very much why we are of the opinion to take the duplication out of the community benefits principles and to ensure that the community benefits principles are focused on those matters that will actually benefit a community. Having matters relating to industrial relations is duplicative. Having matters relating to the taxation is duplicative. There are existing regulations for that. There is an existing legislative framework for those provisions.
And to deal specifically with your question, Senator, I was aware of that. We've spoken with Treasury and expressed grave concern that the penalty for failing to meet one of the prescribed community benefit principles, if it's going to mean that someone becomes ineligible for the incentive, it'll just cut across the entire purpose of the incentive.
And what was Treasury's response to you when you highlighted that grave concern?
Well, they took it on board. We're waiting. I mean, there's been some. I've heard the to and fro's between yourselves and others about industry consultation on the community benefit principles that are going to be included in this, that are going to relate to this specific provision. We've not been contacted yet in relation to that, but we're hopeful that we'll be involved so that we can put our views forward.
Why would the MCA and ACCI agree with the passage of the bill before the community benefit principles had been, until there had been greater clarity provided around the community benefits principles?
Well,
given that this could sort of, advertently or inadvertently lead to increased project costs.
Well, I'll respond firstly. I didn't say I support the passage of the bill. I said I support, or the MCA supports the critical minerals production tax incentive. So we support the concept.
The concept, okay. Not this bill.
Well, we support the bill with that area needs to be addressed. We've raised that point with Treasury, that specific area needs to be addressed. Treasury were hopeful that they were going to include it. They told us in our consultation we did with them late last year, but didn't make it into the bill. And it's, as we know, it's there to be prescribed. We think it needs to be addressed. And we've got time because this measure doesn't start till 1 July 2027.
This is a very, very interesting and I've got to say very peculiar point. Reading all of the submissions, I'd have to say they were quite polite in the way that they navigated the various issues and navigated their support for the principle or the concept and for this bill. But given that the tax credit under this legislation isn't available until 2027, wouldn't it be prudent, given that the risk that exists with an unclarified, duplicative community benefits principles approach, wouldn't it be more prudent to insist on greater clarity around the community benefit principles before the Parliament passed this bill?
That was the view that we put to Treasury.
Thank you. Is that an ACCI view? Would it be an ACCI view?
Yes, that's something we agree with. As I mentioned, we have serious concerns about the community benefits principles, and yes, we'd like greater clarity on them. I suppose we're responding to the bills as they're being brought forward, and so we have expressed our serious concerns with the community benefits principles, and we're hoping that they're taken into consideration with this bill.
So if I understand your evidence from the MCA and the ACCI, there are actually two significant risks that give rise to the argument that the bill should not be passed until these two risks are resolved, and that is the complexities that arise and that already exist in regards to the operation of the research and development incentives and some of the complexities around ATO decisions and interpretations. And in addition to that, the risks that arrive from an unclarified, possibly complex, definitely duplicative community benefit principle approach. Is that a fair summation of
I wouldn't agree that the complexities should necessarily stop the bill, because there are other ways that can be dealt with in terms of ATO rulings, and that is often the way things are dealt with in terms of the ATO and Treasury working with taxpayers to come up with rulings that can be used and followed to determine the nexus issue. But the community benefit principle issue, we would be hopeful that it could be dealt with ASAP so that this bill could be moved forward.
And what's your level of confidence that it will be dealt with ASAP?
I don't know. I mean, Treasury were very responsive in consultation last year to what we and others in the industry put forward as to how the bill should be framed to make it more certain for taxpayers to become eligible. But this was one sort of sticking point that never got addressed and continually sat there. So I really couldn't comment. It's with Treasury.
Thank you very much, Senator Smith. Thanks, Senator Smith, and thank you very much to the witnesses for the evidence that you've given us. The committee's agreed that responses to questions on notice should be provided by the 28th of January, and I'd ask that you now disconnect from the video conference and you go with our thanks. Thank you. I now welcome representatives from the Association of Mining and Exploration Companies and the Chamber of Minerals and Energy Western Australia. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, will you please state your full names and the capacity in which you appear today, and start with AMEC.
Neil Van Drunen, Acting Chief Executive Officer of the Association for Mining and Exploration.
Welcome.
Thank you.
And the Chamber of Minerals and Energy, WA.
I'll start. I'm Anita Lajudici, Assistant Director of Policy and Advocacy for the Chamber of Minerals and Energy.
Welcome.
And I'm Aaron Walker, Head of Economics at the Chamber of Minerals and Energy of Western Australia.
Great. Welcome. Mr. Van Drunen, did you have a brief opening statement that you'd like to give?
I do, yes, and thank you for the opportunity. My name's Neil Van Drunen. I'm the Acting CEO of AMEC. This critical minerals production tax incentive reflects that the world has changed. Since 2010, globally, there's been 1,500 market interventions, or at least 1,500 market interventions to secure domestic development of critical minerals. The largest of these is the US Inflation Reduction Act, or the IRA, which commits over $394 billion in industry support to drive investment into the United States. It includes a $30 billion advanced manufacturing production tax credit, which subsidises the refining of critical minerals. This 10% PTI component of the IRA reduces operating costs in the US for eligible projects. In November 2023, AMEC commissioned Mandala Partners to model how the production tax credit would operate in Australia. The report econometrically quantified that a 10% Australian production tax incentive would reduce the production cost disadvantage faced by Australian projects. However, unfortunately, the PTI is not a silver bullet or a panacea. Australia has long approval timeframes, land access issues, and high construction costs. The PTI must be paired with serious regulatory reform to reduce the regulatory burden faced by companies developing projects. With that in mind, the PTI is a forward-thinking, and positive solution to tackle the supply chain challenges that we face. An Australian PTI would make the cost of doing business, once in production, more competitive. If Australia wants to diversify and to achieve its aspirations to further downstream critical minerals, a PTI will make Australia more competitive. It delivers on the Commonwealth Government's commitments and aspirations that have been outlined in a variety of critical mineral strategies as proposed by both sides of the aisle. AMEC is supportive of the amendments that have been made in the bill as a direct result of consultations with the industry in July 2024. And briefly, they are removing the proposed financial investment decision by 2030 criteria, defining output eligibility on processing activities rather than purity critical minerals, and then also reducing administrative burden by using the existing testing regime of National Association testing authorities, accredited laboratories, rather than the team at Geoscience Australia. In our submission, as I'm sure you've read, we've called for the roles of DISA and ATO to be clearer from the beginning, and we've also spoken at length about the community benefits principle. We've also asked for greater clarity on eligible inputs of what will be considered in the PTI, and specifically called out transport costs for feedstock and reagents needed to be an eligible input. We've also asked that the PTI does not conflict with Pillar 2 commitments and provision be made for franking credits. But finally, improving the efficiency of Australia's regulatory framework remains vital. Currently, the proposal is for the PTI to be only available for income years that start on or after July 2027 and end on or before the 30th of June 2040. However, industry needs support now, not in 18 months' time. Australia is far from alone in trying to develop a critical minerals processing industry. It must compete against the chemical and advanced manufacturing economies of Asia, which offer turnkey or plug-and-play industrial precincts, financial and regulatory incentives, as well as incredibly competitive supply chains. Accordingly, the government needs to do more to lower investment risk, development and operating costs, provide greater certainty on risk and reduce timeframes to market to make Australia a more competitive place to go downstream. And finally, AMEC supports the passage of this legislation. Thank you, Senator.
Thank you very much. And Mrs. Legiudice, do you have an opening statement?
We do. Thank you, Chair, and we'd like to start by thanking the committee for adjusting today's scheduling to accommodate those of us based in WA. The Chamber of Minerals and Energy of Western Australia, or CME, is the peak representative body for the resources sector in WA. CME welcomed the announcement of the Critical Minerals and Hydrogen Production Tax Incentives, or the PTIs, in the 2024-25 federal budget. We've been actively advocating for supportive policy measures such as PTIs for many years in order to compete with increasingly aggressive investment attraction measures in other jurisdictions. However, introducing PTIs will not be sufficient by themselves to achieve Australia's hydrogen and critical minerals ambitions. They need to be part of holistic industry policy that includes streamlined federal and state approvals, productivity enhancing industrial relations reforms, the delivery of turnkey common use infrastructure, and low emissions, reliable and cost competitive energy. These basic fundamentals of land, labour, essential infrastructure and energy underpin all resource sector activities. In particular, we highlight that the CMPTI is not intended to support the upstream or mining segments of critical mineral supply chains, where market conditions for nickel and lithium in particular are very challenging. There's no ability for Australia to move into downstream processing without a sustainable and scalable upstream segment. That said, CME supports the swift passage of the CMPTI as drafted, but believes further adjustments would maximise its impact and ability to effectively compete with other jurisdictions. This includes bringing forward the commencement date to on or before the 1st of July 2026, recognising that intense global competition and challenging market conditions mean that industry needs support sooner rather than later. We also feel the bill should be adjusted to include depreciation, finance, sustaining capital and feedstock or raw material cost as eligible expenditures. These changes would align with the final design of the US Advanced Manufacturing Production Credit and ensure that the CMPTI provides a commensurate level of support. With respect to the HPTI, CME supports the swift passage of the HPTI as drafted to stimulate investment in the supply of renewable hydrogen, which will in turn support the decarbonisation of hard-to-abate sectors, including the potential to develop a domestic green iron industry. CME's submission recommends adjustments that would enhance the effectiveness of the HPTI in supporting the growth of this strategic sector. This includes extending the 2030 final investment decision and 2040 incentive end dates, bringing forward the scheme commencement date to 1 July 2026 and indexing the $2 per kilogram HPTI amount to inflation to avoid its value eroding over time. With respect to the community benefit principles, we note that decisions to provide support under the Future Made in Australia plan, including the PTI measures, must take into account the types of community benefits expected to flow from the provision of this support. CME believes that the WA resources sector is already meeting the intent of the stated community benefit principles. As a result, the implementation of the CBP should not introduce additional duplication and administrative burden. An existing reporting mechanism should be used wherever possible. The assessment of CBPs must be flexible to recognise that benefits sought by local communities, including First Nations communities, differ significantly across Australia. And in conclusion, the CME supports the swift passage of the bill to implement the CMPTI and HPTI in order to support Australia's investment attractiveness in these strategic industries. And we look forward to answering the committee's questions. Thank you.
Great. Thank you very much. I'll kick off. And you've both, in your opening statements there, called for the swift passage of the bill, using words like we need it sooner rather than later, and earlier that we need it now, not in 18 months' time. Could I ask each of you to address what are the conditions that give rise to the need to pass this bill swiftly here in Australia and in the global market to set up these production tax incentives? I'll start with you, Mr. Van Droomen.
Thank you. Well, unfortunately, the world is still moving, so we can't actually wait for the parliamentary process to go and to grind on. The critical minerals space is highly competitive and Australia is in a foot race. So I think back, and in the 1990s, the Japanese invested in research into downstream lithium. So that's now over 30 years ago. But the PTI is what we need to go and address reducing the cost of doing business in Australia. So it's only one part of the toolkit, but it's an important part of the toolkit. And I think AMEC's been at this now for 2 years. We've been talking to our members about the IRA Act since it came in, and they've been saying to us, like, what are we doing? The US has basically designed an instrument to go and suck in as much critical mineral processing to their facilities because they want it. They understand the importance of critical minerals. They wouldn't be called critical minerals unless they were critical. So we've got to do, at the bare minimum, the critical minerals production tax incentive.
Thank you. And Mrs. Legiudice, why sooner rather than later in terms of the global market and the Australian environment?
I'm going to pass over to Aaron, but just at a very high level, securing investment for these strategic industries, the competition is occurring now, which is why, we've been actively supporting a sooner rather than later approach. I'll pass over to Aaron.
Thank you, Anita. Yes, it really is that point that it's an important signal to investors who are looking to make decisions on where to deploy capital. So the sooner we can legislate this, have it available in Australia, investors know that there is support that can compete with what is available in other countries. As Neil has noted, by itself, it may not be enough. It needs to be with that holistic land, labour, energy and essential infrastructure, that combined package that Australia offers investors on why you should bring your dollars here to create jobs, procurement opportunities for local business. So yes, that is why we support sooner rather than later.
And have both organisations engaged in the consultation around the bill, and can you characterise the consultation for us in terms of, sounds like you see some substantial progress in how the bill looks from the consultation, but as is often the case in these Senate inquiries, there can still be issues that people want to pursue. So how do you characterise the consultation and the changes that you've been able to make, given your expertise, Mr. Van Droomen?
So far the process has been excellent. The Treasury and ATO staff have gone on above and beyond, and I don't want to say it's been an enjoyable process but it's been good. So as I pointed out in my opening statement, the movement away from particularly the movement away from using Geoscience Australia as the testing regime. The initial idea had been to take the purity model out of how the IRS do it in the US, and that's really challenging because there's over 30 critical minerals, and they are all bespoke and quite unique. And then you get to things like graphite, which don't actually get purified; they get like sephirized, and they go and get turned into like spheres. There's a word I was hoping not to go and mention during the inquiry, but it's been quite a good consult so far, and we're looking forward to moving forward with both agencies. They know that there has to be more consultation, and they're prepared to do it, from what I can understand. So,
thank you. And did AMEC have anything to add to that around the consultation thus far?
Yeah, CME's experience has been similar to AMEC's experience. The consultation with Treasury and DISA has been fruitful, collaborative. We were pleased to see the changes that Neil has mentioned. Removing the FID requirement by 2030 was a key change for the CMPPI, moving away from the purity model, and also including intellectual property costs and costs for byproducts where there is no market value, to make the incentive more competitive with what is on offer in the US in particular, in terms of the US manufacturing production credit.
Thank you. Thanks, Mr. Walker. And I'll just go briefly before I share the call to the community benefit principles. I think both organisations support the concept of there being community benefit. You've mentioned that that's really important, that it exists, and that your concern is about sort of duplication in reporting. So I wonder if that's a correct characterisation, that you understand and support the need for community benefits principles, but the issues that you're having are potentially around implementation. And I'll just join up my question. So is that broadly correct? And then Will you be participating in the consultation processes on the implementation of the community benefits principles?
Yes, on behalf of AMEC, I would say that we are supportive of the community benefit principles. As Anita mentioned in her statement, we'd support that mining and mineral exploration companies do make considerable contributions in regional Australia. Often they're the only industries out there, and they put a lot of money into the community. Our concerns are around the administration and the reporting in particular. It's not so much, we're not concerned about actually reaching the principles. We know our members can do that. The concern for us is how it's going to go and get reported. And it's not even the early reporting. It's like 5 or 6 years down the track when it's getting a bit more humdrum. And the concern is that the community benefits principle will get linked to how much money you get. And as Aaron pointed out, the financing aspect is key for developing companies, because it's having something like the CMPTI on the table will mean that a critical minerals company can have a more fulsome conversation with international financiers, and they understand the parliamentary. My understanding is international finance guys understand the parliamentary process, but there's a difference between something still being in Parliament and actually being on the books. And we want to get to having it in operation, and then we can have a debate with Treasury and ATO.
Great, thank you. Sounds like, did CME have anything to add to that, or did that cover your?
We'd probably say yes to both of your questions too, Senator, and we did expand on those points in our submission, which I do assume that you have. So really the key points are that we already make a substantial existing contribution and believe that we already demonstrate that we meet those CBPs, and really it is about working with Treasury to work out what the most efficient administrative mechanism is around reporting, and where possible that we're using existing mechanisms rather than creating something new. And then just to go back to my opening statement, it's really about that flexibility that every community that hosts a resource project has different needs, and the CBPs have to be flexible to recognise and allow that to be worked with the proponent and the hosting communities.
Great, thank you very much. Senator Smith.
Thank you very much. Just following from that point, so a question to the CME and APEC. Is there a risk that the CBP obligations will over time require industry to make a contribution above and beyond what is already being made?
I'm not sure there's enough evidence from what we've been told and what we've seen so far, Senator, to support the characterisation of that risk. So,
but Mr. Van Druin, you did say in your remarks that over, I think you might have used a 4 or 6 year time frame, that there was a question mark or some doubt about how the CBP might impact income or revenue being generated.
Yeah, so thank you. I can probably provide further I will provide further detail to that. The concern is that the way that you report, how that is linked to the apportionment of the tax, the CMPTI. So the concern is that if you don't meet all of the eligibility requirements, depending on how it is characterised by the Treasury and the ATO, that will be that's a possibility, but that's a possibility that already works through at the moment with the R&D tax incentive, and both governments historically have written 2 reports on that, including the Tax Institute most recently, which we reference in our submission. So it's a concern because the government is, sorry, Anita, the government understandably wants to get the community benefit principle outcomes, but we need to also make sure that the financing, which is underpinned by receiving these allotments, it still sits there. It's why we've proposed that the community benefit principles are assessed at registration rather than on an annual basis, because it introduces an uncertainty. But that can be sorted out through regulation and process. So,
and I think we do need to recognise the overall value of the industry in and of itself is going to derive a massive benefit for the hosting communities and the nation as a whole. So, you know, again, I think it's premature to be saying that in isolation of looking at what the total value of these two strategic industries are.
Yeah, it's a fair point.
What commitments have you been? So in your opening statements, you've identified some improvements, some enhancements, some matters that you would like to see progressed and ultimately, you know, accommodated or reflected in the final rules. What level of commitment have you been given that they will be actively pursued and that you will get resolution of those matters in the way that you want? So Mr. Van Druin, for example, you identified, I think, seven points in your opening statement, for example.
I did. The seventh one, in fairness, is fairly broad, but my experience with the government suggests that they are improving Australia's regulatory framework. But as for the others,
contested point.
yes, true. Okay. As for all the other remaining six, we are actively speaking to both Treasury and ATO around all of these. Part of the benefit of a Senate inquiry is you get to go and restate all of your positions nice and crystal clear, and that's what we're doing. We've got a whole another year and a half to go and debate, and I look forward to that process. So if we had anything to announce, Senator Smith, we would have put a media release out already. So unfortunately, not yet.
And there's been no formal commitment to us. We are also actively progressing, and we believe that the suggested amendments that we've made, can be well supported by evidence, and we would hope that the Treasury process would mean that, all of these adjustments are actually made, because we don't believe that they significantly change the cost of the overall package, and that we think that the benefit to Australia in terms of the value of these industries and the need to obtain the investment now, these are long-term, very large capital investments. If we miss the opportunity now, these investments will be made in other jurisdictions, and we've lost that investment. It's not going to come back here again. So we believe that we've got good reasons for those adjustments, and we're very hopeful of working with Treasury to get them accommodated.
Given that, and given the comments that Mr. Van Druin made in regards to urgency in his opening remarks, why is industry prepared to wait until 2027?
Well, I'm calling for it to be quicker, Senator.
By 1 year, Mr. Van Druin.
Yeah, that is true. I think. I'm trying to be kind in the realities of how long it takes to get all the
You will not get rewarded for kindness by this government, Mr. Van Druin. I think your members know that. So,
from AMEC's perspective, there are some more details that still need to get worked through, and there is a process that is going to be followed. And so far, to their credit, the ATO and the Treasury have done what they said they're going to do, and I'm looking forward to the consultation on the community benefits principle. I'm sure it's going to be a robust discussion. I've watched the earlier parts of the Senate inquiry, and it's certainly been a topic of conversation. So we look forward to the consultation.
A final question from me, Chair, to the CME and to AMEC. The AMWU has told this committee, when it was considering the Future Made in Australia Act, that these requirements should include a requirement for a union agreement. Do you agree with that?
Do you want to kick off with this one? Because given I've done a lot of talking, but otherwise, oh yeah, go for it, Anita.
Happy to. We were aware of this, Senator, and our submission makes specific reference to the fact that the resources sector has the highest average weekly earnings for full-time adults of any industry in the nation, and we only have a 10% workforce unionisation rate. So we do not believe that a unionised workforce should be a requirement for FMA support.
Thank you very much.
I would note as an advocacy organisation that we can at times ask for a lot of things. It doesn't necessarily mean that they're going to eventuate. And I would suggest that this unionisation request fits into that category.
Well, it depends on the strength of your advocacy, Mr. Van Drooyen.
Well, true.
Thank you. Thank you very much. Thank you, Chair.
Thank you, Senator Smith, and thank you very much to this group of witnesses for appearing today. Answers to questions on notice are due 28th of January 2025, and we now invite you to disconnect and you go with our thanks. Thank you.
Thank you very much.
I now welcome representatives from the Australian Hydrogen Council and Zero Carbon Hydrogen Australia with the Smart Energy Council. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, would you please state your full names and the capacity in which you appear today? And I'll start with the AHC.
Hello, I am Dr. Fiona Syme, the CEO of the Australian Hydrogen Council.
You're on mute there, Mr. Kennedy, I think. We've all done it today.
I'll jump in here. I'm Natasha Surex. I'm the Policy Manager for the Australian Hydrogen Council. It sounds like Lee cannot get onto us, so he'll just listen in for today.
Okay, thanks, Ms. Surex. And that can be an issue that happens, and Secretariat might get in touch to try to resolve that one. And Zero Carbon Hydrogen. We can't hear you, Ms. Kay, I think it is, even though I can see your mute button is off. One minute with you. Why don't I go to the Australian Hydrogen Council for their opening statement, and then I'll come back to you. So, Dr. Simon.
So, Madam Chair, the Wayne Smith from the Smart Energy Council.
Oh,
as
apologies.
well. That's okay. I'm here in Canberra. Thank you.
In person, the old-fashioned way.
In person. Thank you. Yeah, old school.
Thank you. Thanks, Mr. Smith. Start with Dr. Simon.
Thank you so much, Chair. It's a pleasure to speak with you today, and I really appreciate the opportunity to address the committee. So the Australian Hydrogen Council is the peak body for the clean and green hydrogen industry. Our membership includes companies from across the hydrogen value chain. And please note, when I say hydrogen in my speaking with you today, I do mean where it's also used to make derivatives such as ammonia and methanol. Now, we have an enormous opportunity in this country to create a vibrant hydrogen industry, both for domestic and export uses. And this has been recognised by both sides of politics, with the previous government producing one of the world's first hydrogen strategies in 2019, and with the release of a revised version of the strategy with the current government in September last year. And we are extremely supportive of the suite of Australian government policy developments that have been that are in the process of being developed, at least, that impact the hydrogen industry. There's obviously the Future Made in Australia package and what we're here to talk about today, so the hydrogen production tax incentive, but also Hydrogen Head Start, the revised National Hydrogen Strategy, and other really important enabling initiatives such as the Capacity Investment Scheme, the National Reconstruction Fund, policy for sustainable finance, and looking into carbon leakage. So these are all important elements to create the right investment environment for Australian hydrogen projects. Now, I want to be clear that electrification is really a vital part of Australia's decarbonisation, and we support the logic of electrifying wherever this is possible and economic, and then renewables in that role. But this is already not an easy task, with almost 80% of Australia's domestic energy consumption in the form of molecules rather than electrons. So we currently use molecules of natural gas, of oil and coal, and these have the benefit of being able to be stored for a long time, so days through to years, decades, millennia, and shifted over large distances, such as overseas. So molecules of hydrogen can do this too, across a range of technologies, whereas the electrons in direct electricity or saved in batteries cannot, they have limitations. While many applications for molecules will shift to electrons, as we see electrification emerging as a more efficient option for continued operations, there's still a significant portion of industrial activity that will not be covered. And hydrogen is the only large-scale option for decarbonising energy that requires molecules. And importantly, hydrogen also provides a chemical solution to decarbonisation, such as for producing green iron. So this is not an energy question. This is not something which electricity can solve. Now, Australia is also a trusted energy partner across Asia, as we know, and the export of molecules is critical to our ongoing prosperity. To avoid doubt, I also want to point out that nuclear energy is about making electrons, not molecules. Nuclear and hydrogen do not compete. Now, we know we don't get to net zero without hydrogen, but we don't get to hydrogen if we don't have serious government support to kickstart the nascent industry, given that we haven't costed into our economy and therefore passed on to the private sector to manage the externality of carbon emissions. So with hydrogen, we talk about the commercial gap. And we should note that this is the gap between what it costs to make it now, that is with first of a kind, small, complex, integrated facilities without a market, without an ecosystem. We compare that against the cost of achieving the same energy or product outcome by relying on the established fossil fuel industry without a carbon price. Hydrogen is currently uncommercial as a result, despite it being able to solve the hardest part of humanity's existential climate crisis. And that's because we haven't sufficiently valued solving the problem. So this is where the hydrogen production tax incentive comes in. It's not the only solution, but it plays a vital role to close the economic gap, where companies only receive it when they're eligible, including once they've produced hydrogen which meets the criteria. It's an elegant means of incentivising the private sector to make investments that are in the Australian public interest. And this is in the public interest. In the 24-25 budget, we saw 5 industries announced as aligned with the National Interest Framework under the Future Made in Australia Act. Hydrogen was first on the list, and it plays an important role in a further 3 of those sectors. So to conclude, the HPTI signals to Australian investors and the rest of the world that we're serious in attracting project investment. It's not the whole story. We still need demand incentives. We need to see hydrogen head start progress, but it is still in itself fundamental. The risk now is the legislation not being enacted prior to an election announcement and the uncertainty that this brings. A delay would be a serious problem because the rest of the world keeps moving. Investors are looking to invest and they don't need to invest here. And even if we are not ambitious about the new growth opportunities that you've already heard about, such as with exports, we need to recognise that if Australia can't provide a path for facilities to decarbonise, we're going to lose the heavy industries we already have. It's because they still need to make things to sell in a global market that values carbon. They will shift to where the best opportunities lie for them to be able to do this. So from our perspective, we need to stay the course. We need to recognise there's not a do-nothing option. That whilst this is not the perfect legislation, it's better than waiting another 6 months or more to try to work out issues and then find more. We really would like you to please swiftly pass this legislation.
Thank you very much, Dr. Simon. And I'll see now if we can get Ms. Kay, if you were the person giving the opening statement there. Go ahead.
Hopefully you can hear me now. Can you hear me now?
Yep.
Great. So Joanna Kay, Executive General Manager at Zero Carbon Hydrogen Australia. Senator Chair, thank you for the opportunity to address the committee today. We strongly support the introduction of hydrogen production tax incentives. We see this legislation as critical for Australia's leadership in the global energy transition, and it's about unlocking significant economic, environmental and strategic opportunities for the nation. So at Zero Carbon Hydrogen Australia, I represent around 80 industry members. Much like Dr. Simon on the call today, our members are talking about this as a significant opportunity and are requesting that this goes through as timely as possible so that our industry can really receive those market signals that it's so desperately relying on to be able to push forward. This is about opportunities across the domestic landscape for hydrogen, green ammonia, liquefied hydrogen, all of these derivatives that can be produced using these green molecules. But it's also specifically around opportunities in the green metal space as well. Australia is really uniquely positioned to lead this energy transformation. We have an abundance of renewable energy, particularly wind and solar. We have unparalleled foundations of producing low-cost renewable hydrogen in the future. So our opportunity there is tremendous. The global hydrogen market forecast is around $1.4 trillion by 2050. Including around $280 billion of interregional trade, of which I think Australia has a really unique position to be part of, whether with hydrogen specifically or products made from hydrogen in that critical minerals, green metals space as well. We have the momentum. Australia makes up around 20% of the global hydrogen projects that have already been announced. That's more than no other single country for context. It's around $225 billion of industry investment. There is a huge amount of confidence in our industry. Like mentioned from previous witnesses or guests today, there is a huge urgency around this, and certainly we must go forward or we are going to be left behind as well. This is an opportunity that is about economic growth, but it's also about energy security for Australia. We need to reduce our reliance on imported fuels like diesel, and this production tax allows hydrogen to fulfil that space as well. And it also allows Australia to strengthen Australia's reliance on global supply chains as well. I think this is a critical time, not just domestically, but also for Australia in a period of perhaps geopolitical uncertainty as well. We have a role to play here domestically, but we also have a significant international role as our neighbouring countries, those like Japan and South Korea, are actively seeking renewable energy partnerships. And we would like to be that partner of choice. And I think we have a great opportunity to do that. And we can rely on our existing really good trade relationships with those countries as well. The timeliness of this legislation is critical. I know you've heard that multiple times today, but it really is. We hear that over and over again from our industry. It's really a critical point for us, and we're really excited to be here and talk about it. Australia has an opportunity to lead this. We cannot afford to fall behind our competitors like the United States, like Germany or Japan. We must maintain our competitive edge and have a share in this growing opportunity and market. Thank you.
Thank you very much, Ms Kay and Mr Smith. The Smart Energy Council made a joint submission with Zero Carbon Hydrogen Australia. Did you have any additional opening remarks, or will we?
Yeah, just very briefly. So Smart Energy Council just very briefly, where Smart Energy Council is a peak body and peak national body for the renewable energy industry. We have about 1,000 member companies with a very strong focus around renewable hydrogen, renewable ammonia, critical minerals value adding. Members include such companies as Fortescue, Tesla, Quinbrook, CWP Global, many other companies working in this space. Two things I'd just emphasise. One is just the absolute need to pass this bill as soon as possible and before the election is called. That's just critically important for investment certainty. And the second thing is obviously this bill and the production tax credits are a key part of a future made in Australia, and the Smart Energy Council strongly supports the Australian Government's Future Made in Australia package. And I just want to particularly acknowledge the contribution, the announcement of a $2 billion additional commitment to the Clean Energy Finance Corporation today. That's strongly welcomed. That'll make a real difference. And in addition, the $2 billion for renewable or green aluminium that was announced earlier this week, again, critically important, key parts of a future made in Australia, and the production tax credits are absolutely central to that. Thank you.
Thank you very much, and thank you for those opening remarks, Mr. Smith. I'll go straight to you for questions, Senator Smith.
Great, thank you very much, Chair. When we look at this particular initiative, how does it compare against, how does its competitiveness compare against initiatives in other international jurisdictions?
So who are you directing that question to?
To both, yep.
Would you like to go first, Dr. Simon, and then I'll follow through?
Thank you, Ms. Kay. I will do that. It compares favourably. It doesn't mean that we win. So the reality is that the gap to reach commerciality for hydrogen is more than this production tax incentive could solve. So there still needs to be a range of other mechanisms to then close the gap. But each country has its own priorities, and for us, it's then really who are we competing with? Who are the countries that are looking to also make and export, as opposed to use? And I think if we are smart with this and we get it done quickly, and we do the range of other things as well, which are some of the things I've already mentioned around sustainable finance, some of the other announcements, and Wayne just mentioned a couple of them as well. If we can keep the ball rolling, it does make us attractive. We were attractive to start with, but we kind of, I think in Australia, assumed that we would just win and money would come to us, but other countries saw the opportunity. We were not going to, we didn't say, for example, match the Inflation Reduction Act as it was proposed in the US. But obviously the US is confronting other issues right now, and there are some question marks over what even is able to be achieved there. The key question here is to not do this. It absolutely establishes us as having lost, as having not tried. So it could always be better, but my God, it needs to get through the way it is.
Would anyone else like to make a comment?
Yeah, I'd like to just to further add, just to back in Dr. Simon there, it's really important to think about this as one of many mechanisms to support the growth of the green hydrogen industry here in Australia and what that looks like more broadly. But to give you some specific examples, Senator, the Contract for Difference scheme in Japan has been pretty much echoed in South Korea. There's it's a tax bracket that will be matched there. It's relatively comparable, although again, there's still a gap that industry needs to bridge, particularly over the next decade before we see those pricings, that green premium decrease over time. As Dr. Simon mentioned, we were never going to compete with the Inflation Reduction Act, and perhaps there is some uncertainty around that as well, regardless. But what we saw when the Inflation Reduction Act came in a few years ago was that globally, jurisdictions really responded quickly. So Canada responded almost instantaneously with their own mechanism, which mirrored the IRA. The Europeans came out with a Green Industrial Plan. You see jurisdictions like the Indian government under Prime Minister Modi put in a huge emphasis on green hydrogen. They hosted G20, as you know, Senator, last year. They now have the Centre of Excellence for Green Hydrogen. Brazil, for example, their entire national strategy is focused at export markets to Japan, of which we also want to play in that field as well. So highly contested, highly competitive, but we need this in order to stay in the game.
Thank you very much. Is Australia a high-cost jurisdiction for hydrogen projects at the moment? And what are the contributing factors to that high cost?
It depends who you... Sorry, go on.
No, you go, Dr. Simon. I'll go next.
It depends who you're comparing us to and why. I think that we seem to have higher labour costs than some of our competitors. It's It's hard to compete with the Middle East, for example, but we don't necessarily also want to have the same approach to labour. We should be able to produce vast amounts of renewable energy, of high quality renewable energy, cheaply in the long run. And we should be better at that than many other jurisdictions because of the high quality of our coincident wind and solar, and the right policy settings help smooth the path for these things to happen. It's also not just about the cost, it's about the value of us as a trade partner. We hear this from a number of our trade partners. It's that actually value the relationship with Australia as a trusted entity that doesn't carry the same sorts of sovereign risks as some of the other places, such as the Middle East. So we are high cost right now because we haven't got a carbon price that counts sufficiently. We don't have any of the other incentives in place that many other countries have got around the entire energy transition. We have been playing catch up for the last few years to even develop those means. So we are higher cost, but there's no reason for us to remain that way once the private sector investment is brought in to do its thing. And we need the right policy settings to make that happen. There will always be customers for what we provide if we can provide it at a reasonable price. We don't need to be rock bottom dollar.
And just furthering that statement, when we talk about the value of us being a trading partner, if you think about the trade routes to South Korea or Japan specifically from somewhere like Queensland or even WA, they're uncontested trade routes. So that is very, very favourable. And when you look at a geopolitical context where geosecurity, energy security is predominantly one of the key factors that are making the decisions in these jurisdictions that we hope to supply to, whether it be hydrogen or its derivatives or green metals, making sure those supply chains and trade routes are uncontested is incredibly valued, and it's incredible value and difficult to put a price on. The other thing is, if we, like Dr. Simon said, if we create a demand mechanism, then we also, obviously it's supply and demand. I think we all know that. It's very simple, high school economics. You increase the demand, you increase supply, therefore your costs come down over time as well. And just furthering Dr. Simon's point, about 60 to 70% of the cost of PEM electrolysis is the cost of the energy going into it. So we have renewable energy here in Australia. We have a huge ambition, and we could potentially be one of the most cost-effective green hydrogen producers in the future.
Finally, from me, could you explain to me how the community benefit principles work, and what's your understanding in terms of their development, whether they're in the infancy of their development or whether they're in the final stages of the development, and also how will the enforcement of those community benefit principles work from your understanding, or how should they work from your understanding?
Ms. Kay or Mr. Smith, if you want to, I'm happy to answer this as well, but you might want to go first.
Yeah, absolutely. Look, I think from my perspective, we've had the opportunity to work with Treasury over the last 8 to 10 months on what this potentially could look like, and we've certainly really listened to our members as well. I think from our membership base, what we see is that our members recognise the importance and the value of those community benefits, but they also don't want to see those community benefits be a hindrance to the work that they do. This is an opportunity for them to be able to make incredible progress for Australia's hydrogen industry and decarbonisation, Australia's economy, all of those benefits. So we would like to see them kind of reflective in a way that is aligned perhaps to other industries, not over and above those things that are required. From our perspective, the most important thing is, and perhaps there's conversations to be had around some of the specifics of community benefits, and I'm sure my colleague, Mr. Smith, might have some remarks on this as well. But from our perspective, and the things that I've personally heard from members, is that the most important thing here is to get this bill passed and to get it done in a timely fashion. And what comes with that is we will work through the detail later on. I would like to mention, though, one of the issues that has been raised, and I've certainly had that conversation with Treasury, is sometimes, and I think it was mentioned in the previous session as well, there are financial mechanisms that are tied to the community benefits, and if you don't meet them, then that changes. That potentially can cause a bit of financial risk associated with the program. And what we're certainly trying to do with the production tax credits is decrease the risk for the industry and create that opportunity. So that's what we're hearing from members. Recognise that Smart Energy Council and Wayne might have a slightly altering view on that.
Very similar views, and certainly the Smart Energy Council strongly supports community benefits principles. That's been a key part of Future Made in Australia right from the get-go. It's critically important that projects, very large infrastructure projects, are building, are maintaining social licence and are delivering benefits to the local communities, both in terms of jobs and other dividends around that, and that investment is genuine and ongoing. It's important that we learn from mistakes of the past as well. As Ms Kay said, the community benefits principles, I think, are pretty clear in the Future Made in Australia legislation, and we absolutely want that to be passed as soon as possible. Obviously, in direct answer to your question, this is an ongoing, the production tax credits will have hopefully quite a long life. That's quite clear in the legislation, and there will be ongoing discussions, no doubt, about community benefits. There'll be ongoing discussions about all aspects of the bill over time, or the legislation over time, and we'll want to make sure that it reflects both community interests and industry interests. And just finally, I think one of the things we want to absolutely make sure, and this has been our point all the way through the Future Made in Australia process, is that the incentives are put in place, they escalate over time in the same way. Any obligations on projects should also be increased over time, and it's really important that signal is provided to industry about what those expectations are over time, so that industry and projects can actually plan for those obligations. Thank you.
Thank you.
If I go on.
Yes, Dr. Simon, go ahead.
I was going to say, it's very difficult to argue against such obviously reasonable things as safe and secure jobs that are well paid and have good conditions, etc. So I absolutely support that. Our members support the community benefit principles, and particularly in light of this being a reasonable trade-off for significant funding or support from the Australian government to create an industry. The challenge, as I see it then, is in the devilish detail of the compliance and the enforcement of principles. And I had 20 years before my 5 years in this role in the world of regulatory policy and trying to put into place in reasonable kind of objective ways these sorts of high-level principles. And it is very, very difficult. And you can get caught up in a whole lot of small p political challenges in doing so. So I think this is what you're hearing from people. It's what you hear from me. It's the reality of making this enforceable and making it sit neatly with something which is tax law, which is a reasonably kind of binary thing. It's you either sort of meet pretty clear-cut, objectively demonstrable criteria, or you don't. It's not about, well, how fair and how secure was that job? So I think these are challenges, but I'd hate for the endless debate that will happen in deciding these principles to be the reason why we don't go forward with the fact of the production tax incentives and the fact of the principles being meaningful. The rules, the argy-bargy that comes down to who decides and how that works, happy to discuss that. We have a few years, but the legislation, the fact of this, telling us that we have this sort of piece that then investors can look to, do it now. It has to be.
Dr. Simon, would you agree with the comments of the Clean Energy Council, where they have said in their submission that subjective assessments of criteria would erode investment confidence and even make projects unbankable or uninvestable?
I think that the wrong subjective assessments under any circumstance of any decision making could lead to poor outcomes. So yes, that could be a factor. I don't think that agreeing with that statement, whether half-heartedly or wholeheartedly, therefore though means that this legislation doesn't go through now as it is.
Thank you very much. And that concludes the time that we have for this panel. And your evidence has been really clear about the need to pass this bill expeditiously and why. So we very much thank you for your evidence. The committee's agreed that responses to questions or notice should be provided by 28th of January, and we'd ask that you disconnect from the video conference and disconnect in person in Canberra, and you go with our thanks. Thank you very much.
Thank you.
Thank you, Chair. Thank you.
Fantastic. Thank you.
Thank you. The committee will take a short break and resume at 3:45. and I now welcome representatives from the Australian Council of Trade Unions and the Centre for Policy Development. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. For the Hansard record, would you please state your full names and the capacity in which you appear today, starting with the ACTU and Ms O'Neill.
Thank you, Senator. It's Michelle O'Neill. I'm the President of the ACTU. And I've got with me Mr. Sherrill.
Daniel Sherrill. I'm the Senior Policy Officer on Climate and Energy at the ACTU.
Thank you and welcome to you both. And the Centre for Policy Development.
Thank you, Senator. I'm Toby Phillips. I'm the Economic Director at the Centre for Policy Development. And I'll pass over to Mara.
And I'm Mara Hemele, a Senior Economic Advisor at the Centre for Policy Development.
Great, welcome to you both. Ms O'Neill, do you have a brief opening statement that you'd like to give?
I do, thanks, Senator, and I do want to begin by acknowledging the traditional owners of the lands we're meeting on today, the Ngunnawal people, and pay all my respects to elders past and present, always was and always will be Aboriginal land. And thank you very much to the Chair and the members of the committee for the opportunity for us to appear before you today on behalf of the Australian Trade Union Movement. We know that this bill, the Future Made in Australian Production Tax Credits Bill 24, is an essential element in Australians' investment in Australia's economy, in Australian workers, in Australian jobs, and in keeping Australians safe from the worst impacts of the climate crisis. Impacts that we saw all too close in terms of the devastating urban wildfires we saw sweep through Los Angeles just in the last few weeks. It's an investment in reindustrialising our country with the cornerstone net zero industries of green hydrogen and critical minerals mining and processing. And it stands in stark contrast to the LNP's expensive nuclear plan, which it's increasingly clear could only work if we shut down large swathes of Australian industry. Their modelling assumes radically reduced energy demand, which could only be achieved with industry, significant parts of industry, shutting down. The 2023 Sunshot report by Accenture concluded that with production incentives like those contained in this bill, the green hydrogen and critical mineral industries could combined generate $153 billion in revenue every year by 2040. That's because all our major trading partners need them to hit their own climate goals. This bill secures decades of Australians' jobs and prosperity, while helping Australia help the rest of the world cut climate pollution. The critical minerals industry already supports over 13,000 direct jobs here in Australia. The Department of Industry and Science has modelled that with the passage of this bill, that number will explode to an additional 143,000 new jobs by 2040. And there are currently 46 green hydrogen projects in the development pipeline, which this bill will help make a reality. They are slated to create almost 24,000 ongoing jobs and over 168,000 construction jobs. If we fail to pass this bill, we'll be foregoing the opportunity to create conservatively hundreds of thousands of jobs and hundreds of billions in domestic economic activity. The community benefit principles that the government have included in the bill are essential to its success. They are the mechanism through which we ensure a fair share of the wealth that will be generated by these tax credits goes directly to Australian workers and communities, not just corporate shareholders. The US Inflation Reduction Act attached very similar conditions to its tax credits. Conditions on payment of prevailing wages, on apprenticeship utilisation, the number of apprentices, domestic content and community benefits, particularly for low-income, energy transition and First Nations communities. Contrary to the usual histrionic warnings from big business, these conditions didn't scare all the investors away. Quite the opposite. They were essential to the IRA's remarkable success. In just the 2 years since its passage, The IRA has driven almost $500 billion in private investment and created 330,000 new jobs in the US. The community benefit conditions ensured that 75% of that investment went to counties with below average income, and that investment doubled in energy transition communities. The conditions around prevailing wages resulted in employers reporting that it meant it was easier for them to meet their workforce and skill needs than it was prior to the IRA's passage. The Future Made in Australia community benefit principles are similarly essential to ensuring that our clean energy policy delivers for everyday Australians, not just big business. This is about securing a fair social contract, one in which public money is designed to maximise public good, not just private profit. I'm very happy to answer any questions the committee may have, Senator. Thank you.
Thank you very much, Ms O'Neill. And did the Centre for Policy Development have a brief opening statement also?
Yes, thank you, Chair. Centre for Policy Development, we are grateful for this opportunity to participate and provide an opening statement. And I'd like to just start by saying that I'm coming from Wurundjeri land in Melbourne. CPD is an independent policy institute, so we conduct rigorous research and we develop practical solutions to complex policy challenges. For several years now, we've been working to understand the global net zero transition and how Australia can navigate any challenges and take advantage of the opportunities. CPD supports this bill in front of the committee today in its current form. It's an important piece of economic policy, and it's part of an approach that we have recommended and advocated for in the past. In our 2021 report, Making Our Way, CPD analysed the existential challenge.
We've just lost Mr. Phillips for a moment there.
Should I, sorry, Senator, should I jump in and continue from what he was saying, or should we wait until Toby can rejoin?
I think go ahead, Dr. Hammerly.
Yeah.
Apologies, my network.
Sorry. Okay.
Oh, we've got you back.
Apologies for that.
It's okay.
my apologies. I believe I was at the point of talking about our past reports. In our 2021 report, Making Our Way, CPD analysed the existential challenges facing the Australian economy. 50% of our export basket is concentrated in just 5 goods, and there's an urgent need to diversify away from fossil fuel exports. In our 2023 report, Green Gold, CPD proposed a strategy to kickstart new green export industries. This included production credits for key goods, including hydrogen and critical minerals. So this is something we've supported for some time. And quickly, I want to highlight a few features of this bill that make it particularly valuable before I'll pass to Mara to just say a few words on community benefit principles. So this bill is aligned with the Treasury's National Interest Framework. That's a sound piece of economic strategy. It provides support only when something's actually produced, so there's limited upfront fiscal impact until things start getting moving. It encourages legitimate emissions reduction, particularly for hydrogen. It focuses on the critical parts of the value chain, so we need green hydrogen before we can have green ammonia or green iron, and it provides the most support to first movers that make bold investments this decade. I'll just finish up by taking a step back to look at the big picture. So we're on the cusp of global structural change at the moment, change that will take decades to play out. And we know from looking at historic instances of economic transition, from the Industrial Revolution in Europe to the Agricultural Revolution in Asia, that these changes do bring prosperity in the long term, but they can be quite disruptive to society in the short and medium term. And this often exacerbates existing inequalities. At CPD, we want to see structural change in economic transition that strengthens rather than weakens communities and society. And we think the bill and the broader Future Made in Australia agenda help achieve that goal. But I'll pass to Mara now just to say a few words on the community benefit principles.
Great. Yes, go ahead.
Thanks, Toby. On the community benefit principles, we thoroughly support the bill's emphasis on ensuring that communities and workers benefit from the new industries. In CPD's work, we focus on 2 high-level outcomes. So the first is the principle of distributional equity. where the benefits and burdens of economic transition are shared fairly. The second is the principle of agency. Simply put, households, workers, and communities should have a say in their future. The community benefit principles in last year's Future Made in Australia Act achieved these high-level goals. Today's legislation gives the Treasurer the ability to set specific community benefit rules. For instance, we recommend requiring consultation with local communities and Indigenous groups, generating economic benefit in low SES or transition-exposed communities, and encouraging some level of domestic ownership in projects. The legislation also allows the Treasurer to set a sliding scale, whereby the maximum amount of public support is available to firms that achieve the most community benefits. Thank you, Chair. We're happy to answer any questions from the committee.
Thank you both very much for your evidence there. I'll start with some questions from Ms O'Neill. Ms O'Neill, what is the ACTU hearing from your affiliates and members about the Future Made in Australia agenda and the green hydrogen and critical minerals industries?
Thanks, Senator. What we're hearing from affiliates of the ACTU and from workers is that what is essential here is the opportunities to create the jobs of the future. You would understand that the transition is something that causes concern for working people, particularly those who have worked in fossil fuel industries for many years. They've had good, secure jobs where their unions have won over many years improvements in pay and conditions and safety. And people want to make sure that the jobs that are being created in the future are similarly secure jobs, that they're safe jobs, that they're jobs where themselves and their kids and their grandkids have a future. So there is a broad support for the need to make sure that we don't wait. We don't want to see people losing jobs in sectors and industries that inevitably are going to be affected by the transition without the new jobs of the future being created and being there. There needs to be a strong bridge from people to be able to walk from one job into another without a gap in between. So there is broad support for having the Future Made in Australia in a broader sense bill, but in particular this work in terms of critical minerals and green hydrogen. We support that primarily in terms of the jobs, as I've said, but also we know it's essential in terms of the climate crisis. So as well as workers directly affected who are currently working in power and fossil fuel industries, of course, there's not one job, one sector, one industry in Australia, one worker in Australia who isn't impacted by what's happening in terms of our climate. Whether that's nurses dealing with the impact of heat and what that means for people, whether it's teachers in classrooms and dealing with all of the difficulties of that, or emergency service workers dealing with the effect of increasing natural disasters. So we support moving to net zero, and we support doing it in a way that will be good for workers and their families and community, good for the environment and good for our country and our economy.
Thank you very much. I'll go to some questions around the community benefits principles. So we're towards the end of our hearing today, and submitters to the inquiry and witnesses today overwhelmingly support the passage of the bill, and the majority of them support expeditious passage of the bill and would be concerned about any delays. Some of our earlier witnesses expressed concerns around the implementation of the community benefits principles. I'll review the evidence as we consider the report. My understanding is the concerns are not so much about the existence of community benefit principles, but how they might be implemented, which is an area that remains for consultation. Some of the witnesses say that the community benefits principles are potentially duplicative and onerous. And I'm interested to know what you say to those views and why the community benefit principles are an important aspect of actually receiving this kind of future made in Australia support.
Thanks, Senator. Well, we think this is a critical element of the bill. We, of course, also support its passage, but we think having the community benefit principles apply is essential to its success. And we say that because we know our history here in Australia, and we know that in the past, in terms of particularly in the resource sector, where you look at the export of coal and gas in this country, we've seen profits made by very large companies, great benefit to shareholders, but not always seen that benefit shared fairly with the workers, their families and communities that have been affected by that, and in fact, in many cases, across the whole of the Australian economy and community. So this is an opportunity to make sure that the benefits flow fairly, that they flow, of course, to the companies that are investing and that they are profitable and that they see their shareholders benefit, but not solely them. We want to make sure that those very communities and the Australian community who owns these resources, if you think of critical minerals as an example, is able to also share those benefits. And those benefits need to be tangible. You need to see local jobs, as I've been focusing on today, but also to make sure that they are good quality jobs, because those communities will not thrive if the jobs aren't secure, if they aren't safe, if they're not well paid and fair jobs. They also need to see the benefit in terms of local supply chains. This is really important for workers, but also for many businesses, many Australian businesses that we think should be able to benefit from, again, this use of taxpayers' money in terms of being part of the supply chain and seeing the opportunity that's created, particularly for small and medium-sized businesses within these regions and communities. We also support the community benefits that stress the need for skills and training. You want to see the opportunity for people to have increase and improve their skills and have those work in a way that has a long-term benefit and is transferable to other jobs that they may go to in the future, as well as lifting the skills and the capacity of the Australian workforce. All of these things are important, and we also look at what's happened in the US, and we see the very real difference when you look at the Inflation Reduction Act, which had similarly community benefit provisions within it, and how that's made a difference, Senator, in terms of the actual jobs that have been created, where they've been, and the quality of those jobs. And when you look at the analysis now, a couple of years down the track, not only does it show you the huge number of jobs, but it also shows that the employers support the need to have things like prevailing wages as one of the conditions, because it's assisted them to attract the workforce they need with the skills they need to be able to get the jobs done.
Thank you, and thanks for giving that international context there on the Inflation Reduction Act and how community benefit principles have applied there, and how jobs have continued to, of course, be created in the US, and we're all watching that with interest. There will be a consultation on the community benefit principles as part of the Future Made in Australia agenda. What views would the ACTU put forward during consultation on the community benefits principles?
Well, we touch on some of this in our submission, Senator. We think it's important that they be well understood, that they be publicly available, whether the companies that are claiming to meet the community benefit principles, that there be information provided that allows those people who are the beneficiaries of those principles to monitor and see whether those principles are being met, and also to have a capacity to deal with, if the principles aren't being met, what might be a process that is dealt with there. So transparency is key to this, also making sure that there's good consultation about how to practically make it work. Everyone benefits from this if we get it right, Senator. It's such an important benefit for local businesses as well as workers. So we're really keen to see those regions and communities that are being affected by the transition consulted closely about how to design the principles and the rules that apply to them in a way that will be practical and have an impact and be able to be monitored.
Great, thank you. I'll share the call. I'll go to you now, Senator Smith. You're just on mute, Senator Smith.
Thank you, Chair, and thank you very much for your participation today. To the ACTU, could you explain to the committee how you expect the enforcement of the community benefit principles to be undertaken?
Senator, we haven't got a fixed view about this. We're interested in the process that the government's going to undertake that's outlined in terms of their approach to the bill. We think the principles are clear, and as you've heard from me, we support them strongly. But the design of how you make sure that they're being implemented and how you monitor that is something that we're keen to work through with others who also have an interest in this area. We can learn from what's happened in the US that I've already mentioned, but similarly in Canada, where there's also been similar provisions that relate to bills that are not identical but have a similar approach to them. So we don't have to reinvent the wheel. We can look at what's happened, but in some ways, in the area of workers, of course, we have an independent body that supports employers and unions around looking at these issues, but we don't have a fixed view. It's probably easier to look at what might happen in terms of things like the role of the Fair Work Commission than it might be to look at some of the other issues, but we're open to discussion.
What are the options, do you think, for the design of an enforcement regime? You've clearly analysed some of the international comparisons. Is there one that the ACTU is particularly keen to pursue, or a preferred model that the ACTU would like to pursue?
No, Senator, I think I've answered the question in the last answer, really. We are open to discussing what would be practical and what would work in a way that makes sure that we see the investment that's needed, but that we also see the benefits fairly shared.
Do you envisage the community benefits principles operating within existing timeframes of various processes, whether they might be fair work processes, whether they might be existing environmental regulation, or do you see it as in addition to those existing processes?
In terms of the amount of time that's taken or the processes?
The time taken.
Look, I mean, we would hope that it's all done in a timely way. We all know how essential and in many ways urgent the changes that this bill contemplates are. So we think they can be designed and developed in a way where they're done in a timely manner that doesn't delay the investment that's needed.
In your mind, what is a timely manner? Is that a 3-month time frame, a 6-month time frame, a 12-month time frame?
It would depend on the project and where it was, Senator.
Do you envisage the removal of any existing regulations or processes to give effect to the community benefit principle?
No, Senator.
In the explanatory memorandum to the bill at 1.51, that section talks about, I'll read the whole section for your benefit. It says, the rules may also specify that the amount of the hydrogen production tax offset that a company is entitled to for an income year is reduced by a specific amount or proportion if the company does not comply with specified requirements in the rules. Does the ACTU have any view or policy direction in terms of how that amount or proportion should be determined?
No, we don't, Senator.
would that amount or proportion be included in the community benefit principles?
Well, the principles are already in the bill. What's not in the bill is how they operate in terms of rules, which is going to be a process of consultation. So it's not determined yet, Senator.
Do you expect that you would be consulted specifically on the matter of how much by how much or by what proportion the company's tax benefit should be reduced? Is that something that you would? So specifically in regards to 1.51, is that a particular matter you would expect the ACTU to be consulted on, and the views of the ACTU to be given proper regard?
I would hope our views are always given proper regard, Senator, but it's not a specific element that we've focused on in terms of the work we've done in this area to date. But my understanding is that the government's intention is to consult broadly by those people who have an interest in the bill in the design of the next stage of the rules that you're referring to. So I can't imagine that would happen in that you're only in a piecemeal way, and so we would look forward to being part of that consultation. But the particular part of the memorandum of understanding, the explanatory memorandum you're referring to, is not something that we have been directly involved in.
When do you expect the consultation? What's your expectation in terms of when consultations around the community benefit principles should be concluded by?
I would hope, we've got to see the bill through first, Senator, so hopefully this process leads to the bill going through Parliament in the next couple of weeks. And I don't know what the government's intention is, but our view would be that there should be pretty quick turnaround of starting the detailed consultation process about what's needed to have the implementation up and running.
Thank you, Chair. I may have some additional questions.
Oh, thank you very much, Senator Smith. You've left me with a couple of minutes there, which is very much unlike you, Senator Smith, but that does give me time. I'm a man of surprises, Senator Walsh. It does give me time to just ask a question of the Centre for Policy Development, and we very much appreciate you making the time to be with us today. Could you just tell us how you see these production tax incentives as working to help onshore and grow green hydrogen industry, as well as potentially green metals industry flowing from that, and critical minerals processing here in Australia?
Yeah, absolutely. So I think at kind of the biggest economic scale, what we have at the moment is we've got very nascent and volatile global markets. And so from an economic perspective, it's really not clear who has comparative advantage right now for setting up an industry, which means global capital's kind of moving everywhere. That creates a great opportunity for Australia. And in our analysis, we see that over the long term, Australia has massive comparative advantage in these big green industries. We've got on metals, we've got the ores in the ground, biggest exporter of bauxite, one of the biggest exporters of iron ore, and we've got the renewable energy potential to power big industrial processes. So we can kind of say, look, over the long term, Australia should be a really prosperous place for these new industries. But coming back to that short term, we've got very volatile markets. We've got very inconsistent global policy frameworks around how quickly countries are decarbonising. And that means that at the moment where investment decisions are being made are not so much around that long-term comparative advantage, but they're around solving that short-term economics and providing some level of policy stability. These sorts of production credits and the other sorts of policies that we advocate for are really about bridging that gap. And, one of the other great designs of this bill is that it's not a forever subsidy and support. It's very time limited. So it's about saying, let's get these first movers in, set up, build a bit of a beginnings of a new industrial ecosystem in Australia. And then as the global markets settle down, and this is a process that will take 1 or 2 decades. Like, this is a big global transition. But over time, Australia can emerge, if this is managed well, as a big industrial superpower. And I suppose that's where it all runs back to saying, well, we've got to get those first electrolyzers installed and up and running today.
Fantastic. Thank you very much. We're ready to move to our next panel. Senator Smith, you've got one final question.
Just a final question. Thank you, Chair. Just to the ACTU, in submissions to the inquiry and in evidence today, there has been a suggestion that the community benefit principle regime should be satisfied at the registration point rather than annually. Is it the ACTU's view that the community benefit principles should be reviewed annually
I
for
think,
a project?
Yeah, our view is they should be reviewed regularly because we think, as I'd said, Senator, that transparency about their impact and how they're monitored is critical to their success and the confidence people have in this being good public policy. So we don't have a fixed view about that in terms of how regularly, but we would not support that it only happened at the commencement.
Do you envisage a specific?
Senator Smith, that's very naughty of you.
It's a subset of my one question, Senator Watt. Do you envisage a separate, dedicated regulatory function to regularly monitor the community benefit principles? How would you see that working?
I'm not sure I understand your question, Senator. You mean a regular... Sorry, can you explain a bit more what you mean by regulatory function?
How do you envisage the monitoring of each community benefit principles framework applied to each project? How do you see the monitoring regime of that operating?
Well, I think that it'll vary depending on the particular community benefit principle. So, for example, strengthening domestic industrial capabilities and stronger local supply chains, the information and data you'd need to be able to show that will be different to what you might need in terms of developing a more skilled and inclusive workforce. So there'll need to be different data sets and different ways of gathering information as to the impact, which is why I think a next stage of consultation about the rules makes sense.
Thank you very much to the witnesses on this panel for appearing today. The committee has agreed that responses to questions on notice should be provided by the 28th of January. Those of you who are online, we ask that you disconnect and go with our thanks, and thank you to the ACT representatives in Canberra. Thank you.
Thanks, Senators.
Thank you.
Thanks, Senators.
I now welcome to the table representatives from the Department of the Treasury, Department of Industry, Science and Resources, and Department of Climate Change, Energy, the Environment and Water. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. The Senate's resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Officers appearing today are also reminded of the Senate order specifying the process by which a claim of public interest immunity should be raised. Given that the number of witnesses that we have there at the table, I won't ask you all to identify yourselves until we have a question of you, at which point we'd ask you to state your name and the capacity in which you appear. Were there any opening remarks, or are you happy to proceed straight to questions?
Senator, not from Treasury. I might just check with my colleagues from Climate Change and Industry.
None from DISA, Senator.
And none from Climate Change, Senator.
Great, thank you. We'll proceed straight to questions. I'll start with Treasury. Their ears might have been burning when some witnesses earlier were talking about the consultation process. And if you didn't hear it, you should go back and look at the transcript because the process was described as excellent, I think, from mining industry representatives. Can you briefly take us through the consultation process for the production tax credits and key changes that have been made to the bill as a result?
Thanks, Senator. Marty Robinson, First Assistant Secretary of Corporate International Tax Division in Treasury. So yes, it was very good to hear the positive comments from people who have spoken earlier today. We have had quite comprehensive engagement in various stages of the process in consulting on these two tax measures. Just to give you a bit of an overview, Senator, our consultation started just prior to the government's announcement. We undertook some targeted consultation with industry, both in relation to the hydrogen production tax incentive and the critical minerals production tax incentive. That happened during the period of late April and early May. Following the government's announcement at budget, we moved into a public consultation process. We released two different discussion papers, one on each of the production tax incentives, and undertook a 2-week consultation process from late June to about mid-July. As part of that consultation, we received 82 written submissions from stakeholders on the hydrogen PTI. And that included 46 from developers, 7 from industry bodies, 4 from tax advisors, 5 from unions, and 3 from state and territory governments. And we had a number of confidential submissions as part of that. We also received 47 submissions in relation to the critical minerals production tax incentive. We also undertook a number of meetings and roundtables during the period of the consultation. And then finally, we undertook some further targeted consultation with stakeholders around the draft legislation prior to introduction. In terms of, and I should mention to just acknowledge the role that our Department of Climate Change and Department of Industry colleagues took in participating in all of those consultation stages. In terms of changes made as a result of the consultation, so we received a range of feedback in relation to both of the production tax incentives. Probably the most significant changes were made in respect of the critical minerals production tax incentive. We received some feedback from stakeholders that raised some concerns around the proposed 30 June 2030 cut-off date for final investment decisions for projects to be eligible for assistance. Some of that feedback was that the time frames for of development of projects from conception through to the technical design phases and environmental approvals and other forms of regulatory approvals can take some time, and there was a concern that that cut-off date might preclude projects that might even be underway for development at the moment. So the government elected to remove that final investment decision cut-off requirement. There were also some changes to how eligible activities were defined in terms of moving away from strict definitions around outputs to be more activity-based in the outputs. And that ensures that the right kinds of activities are being included and makes the measure more fit for purpose. We also had some other changes which responded to feedback, such as allowing the start date for claiming of the tax incentive to be specified by the taxpayer. And that recognised that sometimes when projects are starting up, they might be starting production, but the production levels might be quite small in the early phases as they're working through the technical sort of implementation, and so that responds to those sorts of issues.
Thank you. There's been a bit of discussion today about the community benefits principles, and those 6 principles were legislated in the Future Made in Australia Act that passed last year. A couple of questions on that. Can you take us through how this bill provides for the community benefits principles to be implemented? And then second, can you confirm that there will be further consultation on the implementation of community benefits principles in the broader Future Made agenda?
Certainly, Senator, and it's been great to see both through our own consultation process and also through the submissions received and evidence submitted to this committee, the broad support for the community benefit principles. Of course, the government's objective here is to ensure that when it's providing substantial support to business, that there is, reciprocal obligation on business to ensure that the communities in which they operate have the opportunity to benefit from, the economic opportunities that are created. As you mentioned, Senator, the Future Made in Australia Act does set out the requirement for community benefit principles in relation to FMIA support. And there are a couple of examples already in relation to grant-style funding support, which those principles will need to apply to. And the government has also stated that they will apply in relation to the production tax incentives, and as you note, and as the committee will see, that that's set out in the legislation. What I would draw the committee's attention to is that we will be distinguishing in how the community benefit principles are designed between how they might operate for support programs, for general support programs, versus how they will apply for the production tax incentives. In particular, in the tax system, it is going to be important that the benefit principles are rules-based and objective rather than subjective in their application, and that's consistent with the general approach, in the tax system and implementation of policies in the tax system. They need to be generally applicable, non-arbitrary, and enable and support the self-assessment system by taxpayers and give certainty. The legislation sets out the framework for the operation of the community benefit principles, and the further detail will be set out in the rules that will be set by the Treasurer. It's going to be important that the implementation of the community benefit principles and the tax system is consistent with the broader support. So Treasury is currently undertaking work to develop a consultation process, a public consultation process on the design of the broader FMIA community benefit principles. And then we will also be consulting on specific arrangements in relation to the production tax incentives with those objectives in mind that I just mentioned. And of course, they will be through a public consultation process, Senator.
Okay, so both consultations will be public in the sense of the Future Made in Australia Act, the consultation around the community benefit principles, and also the sort of slightly different treatment of community benefit principles rules in this bill because of the way in which they attach to the tax system and require special treatment, if you like. both parts of that consultation will be public.
That's right, Senator.
Okay, thank you. We heard some evidence earlier today that applying for the production tax incentives would be simple and efficient and a good way of supporting new firms to grow here. We also heard some concerns that it would be less simple. Can Treasury clarify that businesses would not have to reapply for the PTIs each year and that instead eligible businesses would receive the credit after lodging their tax return?
Thanks, Senator. That's correct. Under both the production tax incentives, we anticipate there will be some kind of initial registration requirement. I think we've stated previously, or the government stated previously, that both production tax incentives will be co-administered between the Australian Taxation Office and the Clean Energy Regulator in relation to the hydrogen production tax incentive and Department of Industry in relation to the critical minerals production tax incentive. So there will be that initial registration process for business. But as I mentioned before, the PTIs will be designed such that they are then going to be available to taxpayers on that self-assessment basis. And would be claimed through the tax system in the way that taxpayers might claim other types of concessions or assistance through the tax system. But I might just see if Mr. Giebers wants to add anything to that.
Adrian Giebers, Director, Treasury.
I think Mr. Robinson's answer might have, been complete there. Probably certainly complete at the level at which committee members and anyone listening might be able to absorb anyway.
That's right.
Any further detail that you had? Yeah.
And Senator, I would just add that there is obviously an annual tax filing obligation for taxpayers in the ordinary course of events, and so we would anticipate that as part of the design of the filing requirements for for the production tax incentives, that the ATO in conjunction with the co-regulators would set out any sort of annual filing requirements.
Thank you. There really was overwhelming support for these measures in the submissions and also in the hearing today. Some people, would like measures to go further, of course, and that's always the case. We did see in some of the submissions, though not so much today, some questions that I might ask you to address around how Treasury arrived at the $2 per kilo tax credit rate for hydrogen production, with some submitters, as you would be aware from your consultation and from the inquiry, seeking that they be indexed over time. How did you arrive at that figure, and why not index it?
Thanks, Senator. So I might give a few comments and then pass to Ms. Zerger, who might be able to elaborate. In very broad terms, we worked very closely with the Department of Climate Change in determining a level of assistance that might be appropriate to deliver through the PTI. We looked at information around the cost gap in terms of production of green hydrogen compared to other production methods, and we took into account some of the considerations around international competitiveness and thinking about what types of assistance were being provided to support industry in other jurisdictions. And of course, the Department of Climate Change has a significant experience from administering of other support programs, in particular the Hydrogen Head Start. In relation to the question around why not indexation, I think our view was that this assistance is really around trying to bring forward investment and help to support investment, particularly for those early movers, and try to encourage early movers and bring forward of investment. And this is partly by design with the time-limited nature of the production tax incentives. Over time, we expect that as the technologies and the production approaches sort of firm up and develop, that the effective costs of production are likely to decline, and essentially holding the $2 fixed at that nominal level acts as a sort of natural taper over the length of the program. But I might just pass to Ms. Zerger just to add any further thoughts on the setting of the $2.
Thank you. Catherine Zerger, I'm the branch head of Hydrogen Strategy at the Department of Climate Change, Energy, the Environment and Water. So the setting of the $2 per kilogram incentive, we have very good kind of industry intelligence with our engagement with the broader hydrogen industry within the department, and as Mr. Robinson raised, our experience with some of the grant programs and project proponents more generally. The HPTI is will also encourage the crowding in of other forms of investment. So we expect that it will be used together with things like Hydrogen Head Start, with state and territory initiatives, but also international incentives as well. So there's significant international incentives, the Japanese Contract for Difference, incentives in Korea, that the HPTI can form a basis in which to attract some of that investment as well. The size of the incentive, it was a balance between also recognising that there'll be cost reductions we expect there'll be cost reductions over time, and setting a number that ensures that we're not over subsidising over time as well. So balancing that.
Great, thank you, Ms. Zerger. I'll go to you now, Senator Smith. If I get time, I've got a few more questions, but I'll go to you, Senator Smith.
Great. Thank you very much. Just beginning with the Treasury, you talked about the reciprocal obligations that are contained in the community benefit principles. Can you provide to the committee an understanding of how they will firstly be monitored, and then secondly, how they will be enforced?
Thanks, Senator. As I mentioned earlier, we are currently going through the work in Treasury at the moment to consider how the community benefit principles might be developed and applied in practice. So it's probably a little bit early to be getting into detail around, things like monitoring arrangements or how they'll apply in practice. What I would just emphasise, as I mentioned earlier, is that we will be going through a public consultation process to work through those issues, and I imagine that they would be, the monitoring and those sorts of things would be part of that.
Is the Treasury modelling its approach on any pre-existing arrangements that might exist across the federal government, or is it creating a whole new model?
Senator, what I would say is that we're certainly very mindful of not wanting to duplicate things that are out there, and I note that a number of the submissions, both to the Treasury process, but I see also to this committee's process, have underscored the importance of avoiding duplication. So we will be drawing on existing frameworks, I would imagine, where possible, to to avoid any duplication. But in some respects, this is this is a novel sort of approach in having a framework sort of underpin those broad supports.
When I hear the word novel, I think of risk and uncertainty. Is that unfair?
I don't know that I'd characterise it that way, Senator. I think maybe I would describe novel as a way. We're thinking about how we can bring a lot of these elements together, under a single framework. I might just see if Mr. Chesworth has anything he'd like to add there.
Senator Smith, Peter Chesworth, Head of Minerals and Resources Division in the Department of Industry, Science and Resources. One of the submissions, I think it may have been from AMEC, but I may be incorrect there, made that contention that it would be helpful if there could be similarity in administrative systems. DISA has for many years partnered with the ATO in the administration of the Research and Development Tax Incentive, which is a multi-billion dollar per year tax incentive to promote research and development in Australian companies. What we're doing, I guess, within DISA is to have a look at ways in which we can leverage those existing methods and relationships and systems so that we don't have to duplicate things again. But, initially we're sort of trying to draw the lessons, but there may be things in the production tax credit for critical minerals that sort of require a new approach. Certainly the scale will be different. The Research and Development Tax Incentive, last count from my memory, applied to thousands of firms, whereas the Critical Minerals Production Tax Incentive is more likely to be in the three figures.
Do officials from the Treasury and other departments that are present expect there to be the removal of any regulatory processes or regulatory requirements in order to give effect to the CBR? The CBP rather? So will there be a net reduction in approvals as a result of the existence of the CBPs and the requirements that are contained in the rules?
Senator, Pete Chesworth again. It's pretty too early to tell, and I may have got the wrong end of the question. We don't know how many approvals there are going to be because the system isn't in place yet, and that sort of thing. Listening to the evidence earlier today, whilst there is, some, submissions have been made about the CBPs and how they're going to operate, but again, there was one submission that sort of said, the certainty of having the community benefit principles in place can actually provide certainty for businesses to invest in the future. So there's that aspect. In relation to what you might call the regulatory burden or the stock of regulation, that's probably a separate issue that we'll have to sort of see as the measure progresses.
Has the government asked that the stock of regulation be decreased as a result of giving effect to the CBP?
Well, Senator, as I mentioned before, we're still in the process of design work here, and we will obviously need to.
So, is a design principle, is a design expectation that there be a reduction in the stock?
Well, Senator,
of regulation and regulatory approval.
I don't know if there's been any specific requests around a reduction in the stock. I think the government would probably want to take the opportunity to see what is being proposed.
I think as a broader principle,
if it's not explicitly asked for that, it's hard to make that assumption.
Well, Senator.
So, what is the time frame? What is the time frame for consultation, and what is the expected date of the completion of the rules-making process for the CBP?
As I mentioned before, we're currently undertaking that work in Treasury, and ultimately the timing for consultation will be a matter for government.
When is the expectation that the rules will be in place?
Well, Senator, I do note that the production tax incentives don't commence until 1 July 2027. So certainly in place by then.
But very generous consultation process for you. Very generous consultation process for you.
But government is very mindful, and we're very mindful of the need to ensure that there's adequate time for business to understand what their obligations might be and be able to factor that into their planning, and also for appropriate administrative processes to be developed.
In the explanatory memorandum, it specifically talks about it at 1.51. It specifically talks about the reduction in... I'll read it out again. So the rules may also specify that the amount of the hydrogen production tax offset that a company is entitled to for an income year is reduced by a specified amount or proportion if the company does not comply with specified requirements in the rule. How will that specified amount or proportion be determined? And will it be different for each project? Or will there be a standard regime?
Senator, as I mentioned before, one of the things around implementing through the tax system is we need to have a consistent rules-based approach to things, so that that helps to give certainty around obligations and also consequences around obligations. Of course, the provision in the bill is there to enable the enforcement of the community benefit principles in an appropriate way, I can't preempt the design as I mentioned before, but it does facilitate a proportional reaction to failure to comply with community benefit principle obligations, but they will be a consistent set of obligations for taxpayers. I think one of the key points around the tax system is the tax system doesn't permit differences, for example, across different geographical regions, so that consistency will be there. The tax system does permit differentiation, for example, between the size of entities, and we do recognise that the expectation around obligations might be different for different size entities or projects.
Thank you very much for that. The Minister, Ms King, and the Treasurer, Mr Chalmers, have said in the media that the idea that tax credits would be reduced if a company failed to comply with the community benefits principles was a lie. Can you explain their comments in the context of that explicit paragraph in the explanatory memorandum, paragraph 1.51?
I'm sorry, Senator, I'm not familiar with those specific comments from either Minister King or the Treasurer, so I'd be cautious about making any judgments about the accuracy or otherwise.
but it's clear in 1.51 that the rules may specify an amount by which the production tax offset that a company is entitled to is reduced by a specified amount or proportion if the company does not comply with the specified requirements in the rules. That's a very clear statement in the explanatory memorandum.
I'd agree with that, Senator.
Thank you very much. I just want to turn to, just before I do, so let me be clear that the commencement date at the moment is 2027, and submissions that have been made to bring that forward by a year have not been accepted by the government?
Well, Senator, as I mentioned, the legislation, as you noted, the legislation has a start date of 1 July 2027.
So no business in Western Australia will get the benefit of this tax incentive until 2027?
That's correct, Senator.
No business in Queensland will get the benefit of this tax incentive until 2027?
That's correct.
Do you want to pass it quickly, Senator Smith? Do you want to pass it quickly?
No, it's okay. You know where I'm going, so I'll keep this very, very tight. No single business in any state in Australia will get the benefit of this tax incentive until 2027.
The tax incentives commence from 1 July 2027, Senator, for everyone.
Great, thank you very much.
What's the benefit? Just Chair's prerogative there, Senator Smith. What's the benefit for investment certainty to businesses of knowing that this legislation has passed and knowing when the start date is that the benefit applies? What's the benefit to certainty for business there?
Senator, so we heard through a number of the submissions and the consultation process that timely passage of the legislation and certainty around the rules for which the production tax incentives would apply would be incredibly helpful for business, particularly as they're at various stages of developing project proposals and seeking investment decisions from boards and those sorts of things. But I might just see if Ms Zerger or Mr Chesworth have anything they want to add to that.
But just on that point, it's not true to say that business certainty is achieved with the passage of the bill, because the rules governing the community benefit principles are the time frame for that is not yet defined. The passage of the bill does not provide the certainty that is.
Yeah, I'll genuinely come back to you, Senator Smith, as I always do. But just on we just talked about the investment certainty from the passage of the bill, but I think there is an important point that Senator Smith raises there also around why 2027 was chosen as the commencement year, and how that interacts with new projects and the phases of new projects getting set up. I presume that there's some years in development before production starts. So how does the 2027 timing work in with the objective of bringing forward investment in new industries that have a bit of a lead-in start-up time?
I might defer to Mr Chesworth or Ms Zerger.
Senator Walsh, these comments are going to be fairly general given the breadth and scope of the sector that we're speaking of. But I guess going back to before the budget, there had been no production tax incentive announced. The budget made the announcement. That announcement in itself would have had impacts on the behaviour of businesses in relation to investment. Also, notwithstanding the fact that the Canadians, the US and other countries had made their own announcements in what is a sector that is reliant very much on the movement of international capital. So I think the best we can do is to say we had that budget announcement that would have had an impact. We've had the consultation, and that consultation has given business the opportunity to understand, define and refine how the legislation is going to work, and that in itself would have had I guess, set them on the course or the runway for the start date of 2027. And it is the case that mining projects, we know that the runway for them is quite long. For these minerals processing projects, we expect that they would be a similar time frame as well.
Thank you. Senator Smith.
Thank you very much. I just want to turn to the matter of compliance. So what is the compliance regime to look like? And have I understood the regulatory impact statement correctly when it says that there's a $100,000 application fee and a $12,000 annual or per year fee? Have I understood that correctly? How do those two costs work?
I might ask Mr. Giebers to respond to that, Senator.
Senator Adrian Giebers, Director in Treasury. The $100,000 is an estimated compliance cost. There is no currently, there's not currently a fee. That regulatory impact statement cost that you reference is an estimated amount that it might cost a business as part of that process. For their internal
cost of business.
For their internal application fees, I understand that includes, seeking tax advice, legal advice, and completing that registration process. And then there is an ongoing regulatory cost as part of that.
And the ongoing regulatory cost is $12,000.
I will be corrected. I understand it might be $22,000 though.
$22,000. Does the Treasury have full confidence that they will be the costs in 2027?
Senator, these are estimates of cost of compliance, and we routinely estimate these types of costs in relation to new policies. There's uncertainty, and of course, costs might vary from business to business. They're meant to be a guide as to the estimate, a broad estimate of what a business might face in terms of their initial upfront process for registration for one of the production tax incentives and ongoing costs of compliance.
I'm assuming, though, when these regulatory impact statements are done, they're done from a conservative perspective. That would be the most prudent way to approach these issues. Think about these things conservatively.
Well, Senator,
the cost could be higher in 2027, let alone beyond 2027. Particularly because you don't have a direction from the government to reduce the stock of regulation as part of this broader initiative.
So, Senator, it may vary from business to business. It may be lower for some businesses.
And can businesses expect those costs?
We've got 2 minutes, Senator Smith.
Well, I will need a little. I notice that the program doesn't have an end time.
It's 5 p.m.
Not in Western Australia. It's 2 p.m.
You've got 2 minutes, Senator Smith.
I would like to ask now, in all seriousness, just in regards to the government's announcement earlier this week in regards to the aluminium production credit announcement. So is the legislative base for that announcement this legislation that the committee has in front of it?
Senator, so that is a separate announcement of government. It is a production credit. It's not a production tax credit. I might see if Mr. Chesworth wants to make any further comments in relation to that announcment.
Thank you.
And if you could just, Mr. Chesworth, if you could just sort of elaborate on the distinction between the two, or Treasury might elaborate on the distinction between the two.
I'm afraid, Senator,
those that are paying attention.
There's not actually much more I can offer because there's another part of the department that looks after it. But we could take it on notice and get an answer that describes the difference if that would assist the committee.
So this particular
that's also a good prompt.
Chair,
it's a good
it's the beginning of the new year.
Know that of course
you are full of generosity. It's the beginning of the new year.
You can put questions on.
No, to be fair, Senator Walsh, there was no concluding time on the program.
I think the Secretary can confirm for us that the time for conclusion is 5 p.m. and that just dropped off when they added the names of the witnesses to the program. So I invite you to put any further questions you have on notice, Senator Smith. So that concludes today's hearing. Thank you very much to all the witnesses who have appeared. Thank you to the departmental officials who have just appeared in this panel. We, as always, appreciate your evidence and your advice. Thank you. The committee's agreed that responses to questions on notice should be provided by 28 January. That concludes the hearing and the committee stands adjourned. Thank you.